I talked to Mr. Wilson about this. And obviously you see his schedule in front of you. He did make on the 2 PM blows, he's telling me he thinks he just fell asleep and missed those. On the 2 AM blows, he was at work, he provided a 4 o'clock specimen, he provided a noon specimen, and from his memory, he thinks he might have blew late on one of them. But that's his recollection.
All right, we talked about this at sobriety court this morning a little bit. The probation officer was here, and my understanding was it was just not submitting the timely blows. I'm going to go ahead and take the plea as though that was the case. If you plead guilty here, this would be 4 technical violations. You could have your probation revoked, and you could be incarcerated for up to 93 days. Do you understand that?
Yep. Yes.
All right. And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you will be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
Okay. Your name, please.
Madeline Marcus, probation.
First one today for her, right?
First one, yeah, first one.
All right. So my understanding is he just submitted, he didn't blow into these timely, right?
Correct. So the first 2 counts 1 and 2 that are listed, he did blow late. So they were, I believe, 40 minutes late and 48 minutes late. Counts 3 and 4, he did not make up those blows.
All right. So do you understand all the charges here?
Yes, sir.
All right. So I'm going to ask you, you understand if you plead guilty, you're giving up all of these rights on the advice of rights, true?
Yes, sir.
All right. Mr. Sparrow, I do have a new appearance from you, do I not?
I will get you one. I did not follow it.
Okay, I'm gonna need you to do that here.
There.
Would you hand him one, Sadie? All right, to the charge that you failed to blow into your sober link on March the 19th at 8 PM, how do you plead?
Guilty.
Did you fail to blow into your sober link on March 19th at 8 PM?
Yes.
Count 2, that you failed to blow into your sober link on March the 21st at 8 PM, how do you plead?
Guilty.
You failed to do that.
Yes.
Count 3, that you failed to blow in your sober link on March 23rd at 8 AM. How do you plead?
Guilty.
Count 4, that you failed to blow into your sober link at 8 AM on March the 24th. How do you plead?
Guilty.
All right. And did you fail to blow into your sober link at 8 AM on March the 23rd as well as 8 AM on March the 24th?
No.
I'm asking, did you fail to do that?
Yes.
All right. And then you did not blow into the sober link on the 19th at 8 or the 21st at 8 PM, correct?
Correct.
All right. Anybody force you to plead guilty?
No, sir.
Plea is accepted to those 4 counts. Okay. Did he blow into the sober link on the 23rd at all?
He did, yep.
How much longer after 8 AM?
He did it again, so 4 hours later was the noon.
How about on the 24th?
Same with that.
At noon?
Yeah.
All right, anything?
Your Honor, speaking with Mr. Wilson, he has throughout this process, he's changed his work schedule. That is an adjustment. On the PM blows, I think he just fell asleep early. That being said, he's taking some safeguards. He now has his phone alarm set for the different 5 minutes before each blow of the day. He's now using a smartwatch, which will vibrate, which he wasn't using before for when he has his at work. He's also got the Alexa set on his house to where it'll tell him that it's, 7:55 or, 3:55. That being said, on one of these also, one of the 8 PMs, he provided a urine sample this morning, as part of his drug drops. Your Honor, if this was a situation where
I don't disagree.
If this was a situation where I think he was trying to
Right,
game the system and he drank, I would have a much different argument.
I got it. All right,
I would ask you to continue to allow him to go ahead.
anything?
I mean,
I messed up. I wasn't trying to beat the court or anything, just
No, you just have to be a little bit more diligent, okay? 4 hours community service by April 21 and $50 in costs. You can pay that by April 21, okay? All right.
Thank you so
Thank you
much.
very much. All right, so this was the beginning of your career there, Ms. Raptis,
Yeah.
right? All right, thank you.
Does he need to go to state your honor? He can just go.
No,
I consider.
yeah, okay, good luck.
Thank
Thanks.
you.
Haupt. Dustin Lee Haupt. 2-6-8-4-1-0-5-7. Your name?
Justin help.
Where were you?
I was at the wrong court. I have a ticket in Canton for an overweight ticket for a work, and I took off out to Canton and thought that that was where I needed to be. And by the time I got back here, it was already too late and missed it.
All right. I don't remember, did you have a lawyer before, or did you waive your right to a lawyer? This is an anti-blight case.
Yeah, this is the one, you recommended that I talk to the prosecutor.
I mean, if you want a lawyer, I'm gonna give you a lawyer.
Yeah, I need to talk to the prosecutor.
Okay, but listen. I'm talking about a defense lawyer. Do you want a defense lawyer to represent you?
Yeah,
He waived an attorney last time, Judge.
Okay, so if you want a lawyer, I'll still give you one. If not, I'll just send you to the prosecutor to talk about this.
yeah, I'll just talk to the prosecutor.
Okay, so you don't want a lawyer. I'm not trying to confuse you, I'm just asking. I'll tell you what, I'll send you to the prosecutor.
And apparently, my assistant didn't get in there on this one. I have a copy of,
327. We filed a reply yesterday as well, but
they filed somehow I have a copy of their reply to my response, but I don't have a copy of my response, and I apologize for that, Your Honor. But I've got a lot to unpack here. They're arguing a summary judgment motion. They're arguing no evidence of elements of the case and asking the court to dismiss. And they're trying to disguise it under a different rule. And 166G is a pretrial conference rule. It is there to identify legal matters to be ruled on and decided by the court, and then enter a pretrial order that limits trial issues to those issues not disposed by admissions, agreements of counsel, or rulings of the court. It's not a fast track to a directed verdict. I think their reply said something about, well, you can convert 166G into a directed verdict. Well, we all know directed verdicts governed by Rule 268, and it's a trial mechanism. So they're trying everything they can to get around the rules and the court's docket control order that had a deadline in November. We were in here, as counsel pointed out, for a trial setting, and I had also filed a motion because we had an affidavits problem where we had filed affidavits against the first defendant, but not the second one. And they argued the DCO then, and now they don't like the DCO, and so they found another rule that doesn't apply, and they're trying.
If you change your mind between now and the time he comes and gets you, just come on back in and I'll give you a lawyer, okay? All right, thank you. That's Eli, isn't it? How you doing? I've been wondering when you were coming in. You don't need to come in the back with us. I'm just saying, when you're coming in here, you're fine. All right, Villegas. Adriana Giselle Villegas, 2-6-8-4-0-3-2-1. Good morning, Ms. Aycock. Your name?
Good morning, Your Honor. Leslie Aycock on behalf of the defendant, Ms. Villegas, who's present to my right. Can you please state your name for the court this morning?
Adriana Villegas.
All right, so you met with the prosecutor. The prosecutor is going to dismiss the super drunk charge, and your client is going to plead to operating while impaired, true?
Correct, Your Honor.
Is that what you want to do, ma'am?
Yes, Your Honor.
If you plead guilty to that charge, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all those 4 points. Your license will be suspended or revoked in accordance with your record. And your vehicle could be or might have to be immobilized depending upon your record. You understand that?
Yes, Your Honor.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You don't have to testify at a trial. If you choose not to testify, if it goes to trial, that silence would not be held against you. You can testify at a trial if you so choose. You do have the right at a trial to question their witnesses, to use the subpoena powers of the court to bring in your own witnesses. Do you understand that?
Yes, Your Honor.
By pleading guilty here, though, you're waiving your right to a trial of any kind, jury or judge. Do you understand that?
Yes, Your Honor.
All right, to the charge of operating while visibly impaired, how do you plead?
Guilty.
Were you operating a motor vehicle in the city of Woodhaven on Western or Ford Lane in Woodhaven at 2:50 in the morning on January 10 of 26?
Yes, Your Honor.
Did you drink alcohol prior to that? And if so, what did you drink and how much?
Yes, I did. And I had 2 beers, 1 margarita, and 2 shots.
2 shots of what?
Tequila.
All right. And was your ability to operate the motor vehicle impaired due to the consumption of that alcohol? And if so, in what way?
Yes, Your Honor. In the way that I hit a curb on the way out, and then it caused my car to break down.
You think you did that at least in part because of your alcohol consumption?
Yes.
Ms. Aycock, this was this a blood draw or an intoxilizer?
Intoxilizer, Your Honor.
All right, you stipulate that the results of 0.175 were accurate.
Yes, we stipulate.
Are you on probation or parole right now, Ms. Vajegas?
No, Your Honor.
Anybody force you to plead guilty?
No.
I'm going to accept your guilty plea to operating while impaired. I'm going to go ahead and dismiss the super drunk. I'm going to refer you for a screening and assessment. You're going to be screened and assessed today. So I'm going to ask you to come to the courthouse. You'll go to probation. You'll fill out a questionnaire and you'll be interviewed, and then you'll come back for sentencing. Okay?
Okay.
All right. So let's pick out a sentence date. Heather, what do you have for me?
Any interest in court to school on April 30th?
Where's that one at?
Trenton High School.
I'm
Yeah,
sorry,
this-
Your Honor, I'm going to be in Wayne County Circuit Court in front of Judge Wanda Evans that morning. I would not be available.
What time is that at?
9 a.m. Me?
Yeah.
From 9 a.m.
All
And
right.
that's court to school time. So we could do April 15th at 8:30.
April 15th at 8:30. Okay.
Yes, as
That
long as the court's aware. I do have a felony, a circuit court Zoom hearing at 9, so I might kind of be bouncing back and forth.
Yeah,
That's
let's
okay.
just set another day. I don't need this to be on a Woodhaven docket day, Heather. Why don't we set it on a Monday? There's no
Okay.
restitution, so
Do you want to do the April 20th? That's a landlord tenant day, but you want to put it in on that day?
or the 13th at 8:30. What's your choice?
I'm not available the 13th. The 20th, I'm open in the morning.
You are open
On the 20th, correct.
April 20th at 8:30, okay?
Thank
And
you, Your Honor.
And you can come on up here now, ma'am, okay? Good luck to you. Thank you.
Thank you.
Herertado. Evan Samuel Herertado, file number 26W841254A. Your appearance,
Good morning, Your Honor. Greg Boulahanis, P36431, on behalf of Evan Herertado.
Mr. Herertado, your name, sir?
Yes, Your Honor, Evan Herertado.
All right, so this is gonna be a plea, I'm sorry, your client pled guilty to operating while impaired. He was referred for a screening and assessment. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
Yes, I have, and there's no material additions, corrections, or deletions, just very brief elocution, Your Honor.
Sure, go ahead.
Your Honor, I just want to make the court aware that Mr. Herertado is working full-time, he's employed full-time, and he's also attending school for global chain management. And so he's been pretty busy. He's already done as a proactive measure before the sentencing, he's done a alcohol drug awareness class to help get ahead of this. So we ask the court to adopt the recommendation of the court, probation.
Anything you'd like to say, Mr. Hurtado?
No, Your Honor.
Why do I get the feeling when I read this report that you're underachieving? Maybe it's just me. You went to UAD Jesuit and you graduated, right?
Yes, Your Honor.
And you've gotten yourself in trouble now twice in a very short period of time. An MDOP, 1,000 or more, but less than 20. Right?
Yes, Your Honor.
That's a felony. You're on Haida probation for that. And then you're in there and you're driving drunk and you got alcohol in the car and you got tobacco in the car and you're only 20 years old. It's time to kind of grow up here, young man. Look at me, please. I'm dead serious about what I'm telling you. You can't be doing this. You don't want to ruin your life before you get started here. 12 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as direct. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. I'm not going to make the testing just monthly. I'm going to make it bi-weekly for 3 months, then monthly for 3, then on demand. Kratom, poppy seed, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. Did your first offense involve alcohol or drugs in any form or fashion, sir?
Your first offense involved alcohol.
Yes, Your Honor.
I'm going to order outpatient substance abuse treatment here. He scored in category 4. I want you to, and have you shown your lawyer? Well, yeah, I want you to go to AA twice a week in person until you're in outpatient treatment. So you go to outpatient treatment, AA twice a week. He's going to hand you a form. I want you to go in person. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you. When I'm talking about that, I mean probation or otherwise. Once you get in outpatient, you no longer have to attend AA or MA. Do you understand that?
Yes, Your Honor.
I'm also going to order that you go to the Victims Impact Panel. That's one night put on by Mothers Against Drunk Drivers. I'm going to order that you pay fines of $300, costs of $250, 75 victims' rights fee, $50 justice assessment. So fines and costs here amount to $675, screening fees $60 for $735, probation fees are $240 for $975. Cost of recovery is $150 for a total of $1,125. I'm also going to order that you serve 5 days jail. I'll give you credit for 1. I'm going to have you serve the other 4 on the court work program. $140 for that, $35 a day. Your total there amounts to $1,265. You may be eligible for early discharge if you are compliant with no prior violations within the preceding 90 days. After 6 months, you can come in here and you can file a petition for early discharge. Listen, I mean what I'm telling you. I'm not trying to make you feel bad. You have to get your life in order here. You're driving around. I mean, you drove into a ditch. You're on felony probation. You got alcohol in the car and you're not even able to legally drink yet. Come on. Don't do this to yourself. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford one. Do you understand that?
Yes, Your Honor.
All right, Mr. Bulahanis, does he have all of this to pay?
Yes, he can pay that. He can pay the $12.65 today, Your Honor. And in addition, I was gonna ask, may he come up to the court to talk to the
Yeah.
probation today?
That would be great. That would be great. So come on up, make your payment, and then you'll go to probation and they'll instruct you, okay, and provide you with a copy of the order. Come on, do better than this. I know you can. Good luck. Thank you. Thanks, Mr.
Thank you, Your Honor.
Do I have Jonathan Hubbard here? Jonathan Hubbard here? Do I have 1, 2, 3 towing and recover? Come on up here, sir. 26W841854. And I'm going to ask you to call in. Mr. McDermott, as soon as I get yours, I will call that. Your name?
Michael Shane, CHENE.
Tell me you didn't drive here from Houghton Lake.
Excuse me?
You didn't drive here from Houghton Lake, did you?
Well, when I work downstate, I'm in the area.
I can't let you, this is a corporation, right?
Yes,
I can't let you appear on behalf of the corporation. I'm sorry. I just can't do it. It's not my rule. I just can't do it. You're gonna have to hire a lawyer. I'll give you an adjournment, but I cannot allow you to appear on behalf of the corporation, okay? I'm sorry, not my rule. All right? So I will adjourn this. Oh, wait a minute. We issued a show cause against you for failure to appear and defend the corporation. This is actually going to be a show cause. Why haven't you shown up?
because once I got back up to Houghton Lake, I work down here 2 weeks, then I go back and I stay. So
Did you call the court and say, can I adjourn it?
No, because I didn't know that the letter came in the mail.
Can you spell your name for me?
CHENEY, Shane, Michael, MICHAEL.
And you are the president of the corporation,
Yes, I'm the owner.
but this is a corporation, right?
Right. Well, it's an LLC, but it's-
I understand. So listen, what I'm gonna do is I'll adjourn this, but you need to hire a lawyer. I'm not trying to make lawyers money, but I can't let somebody appear on behalf of a corporation except a lawyer, okay?
all right.
So is 2 weeks enough time to give you to go get a lawyer?
Yes,
We have April 15th, right, Heather?
That's correct.
You want me to make it a little later in the morning for you?
yes,
How about 10:30? Is that good enough?
that's good.
At 10:30, so you hire that lawyer. We will give you a notice down the hall, okay? Can you call in the prosecutor for me, please, Sadie, 249? And you're all set. All right?
Thank you.
All right, good luck.
And Judge, we also do have one in Calhoun County Jail.
Who's
And he's
representing who's representing him?
Mr. Crawford, he's already
Where's Mr.
met with
Crawford at?
him. He's on Zoom here also.
Okay, let's take this real quick. Derek Schultz, Derek Michael Schultz. I have 26W841842A, B, and C. I'm gonna need Mr. Urick in about 10 minutes, Lieutenant, okay? Where is Mr. Crawford? Mr. Crawford, your appearance. Mr. Crawford, your appearance, sir.
Shows that he's out here.
You have McDermott's file, Mr. McDermott.
Sure. Was it a final?
Mr. McDermott, what case do you have, sir?
Dylan Jacob Barden, Judge.
What do the prosecutor is that?
Did you talk to the prosecutor already?
Yeah, we just need an adjournment so my client can take a driving class.
I don't know why they keep sending me that nonsense. I'm gonna call him in on that too. I don't either. But I'd like to get this gentleman out of the county here.
Barden.
He just poked his head in for about 7 seconds. And Dylan Jacob Barden, 267841449 A and B. I know.
Sean McDermott, on behalf of Mr. Barden, Judge, I have spoken to the
Hang on one
prosecutor.
second. Mr. Urick, your name?
William Urick, I have the city of Woodhaven drawn.
What do you want, a traffic? What, I don't want to do these classes. He's going 38 and a 25, right?
Well, the issue was, Your Honor, and I apologize for leaving my cold.
That's okay.
Conference room. The issue was, Your Honor, that he blew a number of stop signs before the officer finally cited.
We
him.
really need, these traffic classes. I'm sorry. Do we need a traffic class to tell us that we're not supposed to run through stop signs? I mean, what planet would you have to be on to have to go to a traffic safety school to know that you don't run stop signs? I just don't believe in these classes. I'm sorry. If you want to play a harder role, that's up to you. You guys, but I don't want to adjourn these out and have these guys go do.
No, if we could set it for a formal, then, Your Honor, it would serve the same purpose.
How long is it going to take them to get through the class?
Inside 30 days, Judge.
Why is he running? Why is he?
So the issue is the young man, who is a young man, had a hazardous action on a moped.
Where's he at? Where's he at? I think it would be nice for him to be here next time. He doesn't
I can
have
have
to
him,
be,
Judge.
but
I
I'd
can
like
have
to
him
talk
available.
to him. If he's going to drive like this, maybe he needs to push the car. So I'll go ahead and adjourn it
Thank you, Judge.
for 4 weeks, but that's it though. Okay. And I really want your client on Zoom next time, Mr. McDermott. Okay.
He'll be there, Judge.
All right. Adjourn it to the 29th. Is that going to give everybody enough time?
Yes, Judge.
I just don't want Mr. Urick. We'll do it at 9 o'clock. Okay. April 29th. I just really don't want to do these class things. Okay. I really don't in the future. All right.
Understood, Your Honor.
Okay. So I'll make this one April 29th. Thank you. People against Schultz, Derek Michael Schultz, 267841842A and B and C. Mr. Crawford, your appearance.
Good morning, Your Honor. Michael Crawford representing Mr. Schultz. Mr. Schultz, please state your name for the record.
Derek Michael Schultz.
I have a possession of a controlled substance charge. I have possession of drug paraphernalia, and I have a retail fraud charge. As I understand, first of all, does he stand mute and waive formal reading on those?
Yes, Your Honor.
All right, so I'll enter not guilty pleas form. Now, as I understand, he's going to plead guilty to possession of drug paraphernalia and attempted retail fraud. Is that true?
That's correct, Your Honor.
All right. And sir, state your name again, nice and loud for me, please.
Derek Schultz.
All right, so if you plead guilty, did you hear what your lawyer said?
Yes, Your Honor.
If you plead guilty to drug paraphernalia possession, the possible penalties are up to 500 fines, 90 days jail costs, or all those. If you plead guilty to attempted retail fraud, the possible penalties are up to 250 fines, 45 days jail plus costs, or all of those penalties. Do you understand that?
Yes, Your Honor.
And if you plead guilty to those two charges, I'm going to go ahead and dismiss the retail fraud charge on motion of the prosecutor. And I'm also going to dismiss the possession of a controlled substance on motion of the prosecutor. Do you understand that?
Yes, Your Honor.
Now, you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to trial by court or jury. You have the right to question their witnesses, to bring in
revoke the day off I gave the jury.
Oh, no. I didn't think it.
I'm thinking more of it's time to cut an alternate and we move forward.
Oh. Can I talk to my client about that?
Yes.
Oh, I did not even think about that.
I really don't want to renege on the day off that I've given them on Monday. They may have made plans.
No,
It's
they
a
certainly
holiday
made
weekend.
plans. At least one of them certainly has, and I didn't think about that. Can we have a moment, Judge?
Yes.
Well, I don't think so, but it's not like, you know, the mess.
How do they have that number?
I know. They must be giving them. Cause
Look that up, Jill, people.
Mr.
That is
Do you know
not
that, the phone number here?
832-927-2205. I think. I mean, that's what it says.
Okay,
Let
yeah,
me try. Let me try that.
I see nobody's transferring them in.
No, nobody
How do you know
should.
this transfer? They don't show some.
Nobody's transferred a call since I've had the bench.
I see. All right. Well, that eliminates it.
Yeah. That's the number.
That's it.
832-927-2205.
Okay, yes, Judge, I'm gonna add it, I'm gonna get with her, yeah.
Okay.
Yeah, oh, and I was gonna say about the Monday, a lot of them were saying that they made plans, they're gonna work or catch up on some things, you know, things at home, so.
Okey doke.
And I don't lose a majority of my life.
All right.
Judge, is there a number, sir?
It's anonymous.
So there's no numbers?
Just anonymous.
Oh,
That was me.
Oh, the 9:10, that's when it started?
Yeah.
Okay.
I don't know how to get anything else.
Okay, no, I think. Okay. But for now, maybe someone.
Nobody should have that line.
If we get more, I'll get the numbers from.
Yeah,
And
I'll let you know.
So they can looking at some of these people.
Okay.
I mean, look. We're gonna say.
Any input from your client? Any input from your client?
Me first, we are not agreed here. Our position is, number one, the absolute thing you can't do is take back what you told the jury about Monday. That's gonna get people angry at everybody and will cause problems. Two, moving to Wednesday, gives 5 whole days between evidence and closing. It's an extended delay. It's inappropriate. Memories almost will fade at that point, given the number of days and off and everything. We've been diligent trying to maintain this jury. It's unfortunate this juror made a mistake. But closing on Tuesday is important for the rest of this jury, as well as for the logical and most appropriate presentation of the case. So we think, in light of the unfortunate error, that the juror should be replaced with alternate number 1.
And Your Honor, we respectfully disagree.
You really want me to push this to Wednesday?
I would not prefer that the court do that. Obviously, it's out of my control. I told the court I would oblige a Monday if that were to be the case, if the court were to explain to the jury of the happenings. My point would be, we've had a number of minor jury issues, some more.
They're not minor jury
Yeah, we've
issues,
had-
they're
well,
major jury
We've had a
issues.
number of jury issues throughout, Your Honor, and one actually being required to have sheriff involvement, as I'm sure the court remembers. So this lady, who, if I understand correctly, this is the juror that is sitting on the corner over there.
I believe she's on this chair. She's the one with the mask and this one.
The one with the mask, and again, without playing any cards, she is the only African-American juror on this jury. She's sat through this entire trial.
You know we can't go there, sir.
No, well, my point being is that she sat through this entire trial. She's literally been here attentive throughout the entirety of the trial. If there's anything that could be done to have the jury come in on Monday to hear closing arguments and possibly begin deliberations on Wednesday, or whatever needs to be done, we don't believe that at this point, this woman had been taken off of work and interrupted her life to be throughout this entire trial and hear the evidence attentively as she has, that she should lose the right to deliberate this case simply because of a single appointment. So whatever accommodations would need to be made to allow for her to deliberate this case, having considered she
I
sat.
don't think you're gonna like the accommodations I'm about to make.
Well, I
Are
don't,
you prepared to open this courthouse on Friday and pay for security and climate and everything else?
me personally,
Well, you're the parties in this case.
I don't know that that would be the only accommodation that could.
Well, what's the other accommodation?
Would be possibly to begin on Monday or possibly Wednesday. I know.
So you want me to tell the jury that you want them to come back on Monday? Because I'm not telling them I want them to come.
Certainly, I wouldn't prefer, I don't think it would be appropriate to tell them that I want them to come back on.
Well, that's what you're asking for.
No, what I would ask, Your Honor, is that they be given the option of either coming in on Monday or possibly on Wednesday. To the point about memories fading, I think that's the entire purpose of a closing argument. You're going to remind them of the evidence that they heard. Both he and I will be doing an hour and a half, reminding them and going through the evidence that he's.
Well, let's go back. You get an hour and a half if you're done with your case on Thursday. Otherwise, it's about 15 minutes. I'm serious now.
Okay, well, understood. I will do my part to make sure that this is expedient as possible. I think Kevin is committed to the same thing. It won't be me that will make this case go into next week. My cross-examination.
I actually don't believe that at this point.
Well, I'll do my best, Your Honor, to be as efficient as possible with the court times.
Well, just know that time is coming off your closing if we don't end tomorrow.
As long as it's mutual, I'm.
100% mutual.
Understood. We'll work together to make this as efficient as possible. I don't think either of us would prefer a 15-minute closing, Your Honor. But certainly, I think there's accommodations to have them come in on Wednesday, possibly to begin deliberations. And to the point about the memories fading, we will do our best to make sure that they're reminded of.
Well, here's the deal. I'm not bringing them in on Monday. So your issue is, do I bring them in on Tuesday or do I bring them in on Wednesday? And if I bring them in on Wednesday, Ms. Wanda is off this jury.
So Tuesday is the day that she wouldn't be available. I thought Tuesday was the.
Tuesday's the day that, well, right now, Tuesday's the day she's not available.
Okay.
So, yeah, that's the problem. She got the date wrong, as I understand it.
So we either start closings on Wednesday with Ms. Wanda, presumably, or we start closings on Tuesday, as we talked about yesterday, without Ms. Wanda. One way or the other, it's happening next week.
I would prefer Wednesday, Your Honor.
And we would for Tuesday, and I'll just mentioning the obvious. The other major juror break was before evidence had even started. It was an inconvenience. It doesn't create this huge gap between evidence and closing. It's an entirely different situation here. So we would prefer Tuesday.
It would just be a one-day difference, Your Honor, whether they hear it on Tuesday or Wednesday.
Y'all don't think I have anything else going on my docket?
I totally understand, Your Honor, but literally we would be doing the absolute last thing in this trial to allow this jury to deliberate. And at that point, they would be in the jury room and the court can conduct business as usual, with the exception of that.
I can't do my business as usual. I have no idea how long this jury is going to deliberate. There's a lot of numbers between 0 and 50 million.
Understood, Your Honor. I would prefer Wednesday, respectfully.
Okay, I'll take it under advisement. Bring them out.
Thank you.
Yeah, well, while he's just, I just wanted to, give you a quick update on the day.
Sure.
We originally thought we had 3 witnesses today. We may only have 2 because I got a little issue with another witness. It will not affect anything going forward. It may make us
You
stop
can go
early.
into next week all you want.
No, it
I'm just
will not.
taking time off your
It will-
closings.
It will not affect anything going forward. We may have a shorter day today, like I told you we might, than I expected. It will not impact tomorrow or anything else. I
Okay.
will not allow.
Okay.
But I just wanted the court to know,
I appreciate the update. What? Hmm?
and just while we're just talking off the record, I was misremembering thinking we got an hour for opening. We got 45 minutes. I'm not sure even, assuming we keep schedule, we need double that time for close. Like I said, an hour 15 would work for us too. But if you want to stick with an hour and a half, that's fine.
I'm gonna stick with an hour and a half as long as y'all finish tomorrow.
Fair enough. Fair enough.
First go?
Yes.
Oh, there she is. All right. Ma'am, you are before the court on a misdemeanor citation that alleges that on or about October 12th, 2025, at the location of 3160 Laurel Road, that being the Kohl's store, that you did commit the offense of retail fraud in the 3rd degree. Do you understand the nature of that charge?
Yes.
That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court cost. Fine could be increased to 3 times the value of the property taken. That's greater than $500. That would become the maximum fine. You understand that?
Yes.
All right. First question I have for you is, do you wish to be represented by an attorney?
Yes.
This is a public defender case.
Assistant Public Defender Natalie Tate with and on behalf of Ms. Bristow, we would waive any formal reading of the complaint. My client stands mute, and I would ask for an adjourned pretrial date to receive and review discovery, please.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea on her behalf. Pretrial in this matter will be set for 15th, 2026, 9 a.m. Whereas your invite indicates will set the defendant's bond at $5,000 personal recognizance bond, although under standard conditions, including no assaultive behavior or possession of any weapons, ammunition, or anything fashioned to be a weapon. Although there are no alcohol, recreational marijuana, or any illegal drugs. I will also order, ma'am, that you are not to go to any Kohl's store in the state of Michigan. You understand that?
Mhm.
Is that a yes?
Yes.
Anything further?
Nothing further, Your Honor. Thank you.
Thank you. Thank you, ma'am.
So,
Thank you. I'm allowed to leave now?
Yes.
Cool.
Court does call the case, People versus Leandra Hardesty.
Good morning, Your Honor. For the people. Good morning, Your Honor. Dan Garrett on behalf of Ms. Hardesty stepping forward. State your name, Leandra.
We have a jam-packed half day of fun. Mr. Tibbs, are you calling the first witness?
I am, Your Honor.
Go ahead.
Defense calls Joel Thompson.
Good morning, sir. Would you raise your right hand for me? You solemnly swear and affirm that the testimony you are about to give in this cause will be the truth, the whole truth, and nothing but the truth. So help you God. All right. Have a seat. Watch your step on the way into the witness box. While you get situated, I'm going to introduce you to Abby Coronado. She's sitting directly in front of you. She's the official court reporter of the 215th District Court. And she would like to take a really clean record here today. So if you can, allow the lawyers to ask their questions, finish their questions before you respond. They're going to give you the same respect. They're going to let you respond before they ask their next question, okay? Please speak slowly and articulately, and she will get the best record she can. All right. With that, go ahead, Mr. Tibbs.
Good morning, Mr. Thompson.
Morning.
Why don't we start with you introducing yourself to our jury?
Okay. So I'm Joel Thompson. I'm one of the emergency response specialists at Sasol.
And are you the emergency response specialist who responded to Mr. Francis's incident back in March of 2021?
Yes, sir.
Your Honor, may I approach?
You may.
I heard you identify yourself as an emergency response specialist. Is that your job title today?
Correct.
And was that your job title at the time of the incident?
Yes, sir.
Okay. What does an emergency response specialist do?
So for our facility, we do anything that has to deal with hazardous materials, medical emergencies, fires, rescues. And we do that on site at the plant. And we may also in the community provide assistance to other agencies off-site, which could be another refinery, could be another municipal department close by that needs assistance, or like the state yard. Everything that's what we do.
I don't think I asked, but I should have. You work for Sasol, right?
Yes.
An emergency response specialist, is that like a paramedic?
So we have on our team, there's always one paramedic on the team, which I'm the paramedic of the team. But I also do the fire rescue and all that other stuff. And then we'll have a supervisor as well. And then at times we'll have a third person who would be considered like the firefighter.
I got you. I heard you say that part of your job involves responding to emergencies on site and off site.
Correct.
On site, would that be the plant?
Yes.
Okay, so emergencies within the Sasol chemical plant.
Yes.
Okay. What about, can you give me some examples of types of incidents that you would respond to or do respond to off-site?
So we'll have, if there's a car wreck right outside on the highway, we may respond to that. We may respond to, if there's a fire at one of the facilities next to us, or if there's we've responded to like woodland fires outside the plant, assisting other agencies as well.
Car wrecks, nearby car wrecks, fires at other facilities.
Correct.
Anything else?
That's if there's a major like hazardous materials release, we're specialists in that too, so they may, I haven't had to do that, but that's another one of our titles that we can do.
Okay, we know this incident occurred in the sit yard.
Correct.
Is the sit yard, does that fall under the on-site response bucket or fall into the off-site response bucket?
That'd be off-site.
Off-site. And obviously, that's what you were doing on March 7, 2021.
Yes, sir.
Okay. Can you tell us a little bit about your training and how it is that you became to be an emergency response specialist for SASL?
So I started in 1996 as an EMT, and then got my paramedic 2 years later. And
Let me just stop you there if you don't mind. Where did you go to become a certified EMT back in 96?
in 96, I did it in Western Iowa Technical Community College up in Sioux City, Iowa.
Okay.
And then moved down to Louisiana and went to Lafayette Technical College in Lafayette, got my paramedic. And then recently in 2021, I got my registered nurse. And in between all them years of, got my firefighter and then got my industrial firefighting, rope rescues, through TEEX, which is in College Station, Texas.
Okay, so certified EMT, certified paramedic, registered nurse, certified fire response rope rescue. How long have you worked at SASL?
8 years this month.
2018 or so?
Yes.
All right, let's go to the date of the incident, March 7, 2021. You remember that date, I take it?
Yes.
Okay. Where were you when you first learned that there'd been an incident in the sit yard?
So we have they call it the Safety, Security, and Emergency Response Building. It's like our fire station at the plant. And I was sitting at my desk when we're notified by our dispatcher that we had a man down in the sit yard.
And where is the building your desk in? Did you say that what's the name of that building?
The Safety, Security, and Emergency Response Building.
And how far away from the sit yard is your building?
Probably 2 miles, mile and a half.
Okay, you'd have to drive, I think.
Yes, we gotta drive out the gate and then into the other area.
Okay, I'm gonna hand you a couple of documents that have been admitted into evidence. The first is Plaintiff Exhibit 78, which I believe is called the Run Report. And the second is SASL Exhibit 24, which is entitled Emergency Medical Treatment Form. You recognize those documents, don't you, sir?
Yes.
And on Plaintiff's Exhibit 78, Tristan, can you pop that up for us? It includes a timeline of events that might help establish the sequence as events unfolded on the day of the incident. So let's create a timeline.
Okay.
March 7, 2021 timeline. What time did you receive the call from your desk in the ERT building that there had been an incident?
At 12:29.
12/29. All in incident. Okay. What did you do when you got the call that there'd been an incident in the city yard?
So I got up from my desk and Eric was in the office right next to us. Eric is my supervisor that was working at the time.
You say Eric, is that Eric Hanchett?
Eric Hanchett,
He was here last week.
right?
Have you two worked together?
Yes.
Okay, go ahead.
So I got up and said, let's go. We got one at the sit yard. And I exited the building. We go out into the little bay area and I got into one of the rescue vehicles and then Eric got in the other one and we started responding.
Okay, so you two left together but in separate cars, is that right?
Correct.
Okay, now, at what time did you and Eric arrive in the city yard?
At 12:35.
Okay, so you arrive at the sit yard, what did you do?
So when I got to the sit yard, actually en route, our dispatcher had called us and said that, gave us a little bit more of an update that there was a man under the train. So at that time I said, get Acadian en route.
Who's Acadian?
Acadian's our EMS provider in the area because we don't transport. So we had to get an ambulance on scene.
Okay, so Acadian's the ambulance.
Correct. And I believe I called for air med as well at that time to the scene. Because I didn't, I figured that there's a man under a car. We need everything we can get.
So you're on your radio calling in for additional
Yes.
support on your way to the sit yard to begin rendering aid?
Yes.
Okay, so you arrive at the sit yard at about 12:35,
Yes.
and where'd you go when you got there?
So when we pulled up, I got out the vehicle, grabbed we have a trauma bag and a advanced life support bag. I grabbed those and walked across. It was one section of tracks, or I don't remember exactly, but I walked up onto the scene and I could see the Savage guys, were all in one area. Walked up to them and I could see Mr. Francis under the rail car.
Okay, so now you and Mr. Hanchett are at the rail car site?
Yes.
Where Mr. Francis is?
Yes.
Okay, paint us a little picture, look around. Who else was there when you arrived at the rail car?
There was, I think, 5 Savage guys, estimate about 5 the rail guys there.
What about anybody from Acadian? Was the Acadian ambulance EMT personnel there?
No.
Other than Mr. Hanchett, who came in the car behind you, is there any other Sasol personnel there?
No.
Do you know who Anthony Bordelon is?
No.
Do you know who Scott Tyler is?
Yes.
Who is Scott Tyler?
So he was our senior safety manager at the time, but he's retired now.
He's retired.
Yes.
Okay. Was Scott Tyler on the scene when you arrived?
No.
You sure about that?
Yes.
You mentioned you called in the airmen, the helicopter, right?
Correct.
Had the helicopter arrived?
Not yet.
So when you got to the rail car, it was you, it was Mr. Hanchett, several Savage personnel, and obviously Mr. Francis.
Yes.
When did the Acadian ambulance arrive?
At 12:48.
So what are you doing between 12:35 and 12:48 when Acadian arrives on site?
So I went up to Mr. Francis and got down. I said, how you doing? What's going on? We talked. He, I don't remember all the stuff we said while we were, there. But he said, his arm was caught and, that he said he wasn't hurting a whole lot. I checked him out, he's a little sweaty and, but he was talking to me good. His skin color looked good. I went out around, walked around the side and I could see his arm, had a pretty bad arm injury. Come back around, that's the only injury I seen was the arm. Like his legs were fine and everything. Come back around and I started getting some vital signs on him. I hooked him up to the EKG monitor and I attempted to start an IV, but I couldn't quite get a good IV and I blew the vein. And then.
What does that mean?
So when you stick an IV and you don't go in the vein, it'll miss the vein or whatever, and they call it blow the vein. So got all that stuff out. That's when the ambulance started showing up.
So you're rendering aid before the Acadian ambulance arrives?
Yes.
And looks like, according to our timeline, you were there for about 13 minutes.
Correct.
From the time you arrived to the time the ambulance arrived.
Correct.
So if anybody has told this jury that the Acadian paramedics arrived on the scene first and that the Sasol EMTs were nowhere to be found, would that be correct?
No.
Okay, what happened when the Acadian ambulance arrived?
So they showed up on scene and I told them, I said, I'm going to get up under the train to see how we can get Mr. Francis out. And I said, if y'all could, establish the IV and all that. I crawled around the backside, under the wheel, got up and close and personal with Mr. Francis and got to looking, and I didn't see anything like, no outright major bleed or anything like that, but I brought a tourniquet with me. And then I was having difficulty in the position he was in, like kind of almost next up to the wheel and the rail where his arm was. And I couldn't quite get a tourniquet around it. And then I come back out and I talked to the Savage guys and I was like, is there any way we can like back this train up a little bit where it's not going to like jerk or anything like that? Can we just ease it just a little bit back? And I said, I'm going to tied a, what we call Curlex, which is a roller gauze. It's just like like a gauze pad, but it's in a roll. And I said, I'm going to go ahead and I'll put that on his arm. I'll crawl back under there with him and get up and close. And I said, if we can back that off, I said, I'm going to pull his arm back in. That way it's free and clear. And then we can get the train off of us. So we had a little discussion. It didn't take long, yeah, they said they could do it. And then I said, well, I'm going to go under there with him because if there's anything was to happen, like if we were to move that and it starts spurting blood and the tourniquet's not on correctly, I said, I want to have some gauze and stuff. I want to be under there with him so we can render aid immediately.
Okay, before we get to that, I don't mean to cut you off because I definitely want to talk about it.
Okay.
Now, what time did the Acadian airmen helicopter arrive?
So prior dispatch 12:53.
So what I'm asking, was the airmed team on site as you were helping extract Mr. Francis?
Yes.
Okay. So 12:53. Airmen arrives. Now, while you're under the train, yes?
Mm-hmm.
And while you're under the train, did you administer any pain medication, anything like that?
No, Acadian gave him some.
Acadian gave?
Yes.
Okay. So turn with me, if you would, to Exhibit 24. And there's another timeline on this emergency medical treatment form. Can you tell the jury what this document is?
So this is what the paramedic fills out anytime we do a medical treatment on a patient.
And in this case, the paramedic was you.
Yes.
You include some information about the details of the emergency response, and there's a timeline, a treatment timeline in the middle of the document. And it indicates that at 12:58, fentanyl was given by the air med crew.
Correct.
Okay, is that consistent with your recollection?
Yes.
Then it goes to, it also identifies the time the train was moved from off of Mr. Francis's arm, correct? And what time was that?
13:06.
Which, if I'm looking at my watch, that'd be 1:06?
Correct.
Okay. I want to show you a photograph. Tristan, can you pull up plaintiff's exhibit 103? Because I want to get a clear understanding of how it is that you were able to extract Mr. Francis from underneath this train. So can you sort of walk us through how you and the Savage personnel and the Acadian personnel managed to achieve that?
Yes. So.
And would it be helpful if you got up and started?
Yeah, can I-
think Your Honor, may the witness get up and illustrate for the jury exactly what happened?
So I'm in the red shirt, right there, and I'm kind of between, Mr. Francis's legs, basically, kind of how I am across him. And his arm was pinched. I guess the flange of the wheel was kind of, it had it pinched on the back side. You can't really see it right there, but there's like a little flange that sticks out, and that's what was holding his arm next to the rail. So what we had to do was back this car up just a couple inches this way.
And you say this way,
That's
photo
to the-
looking at you to the left.
Yeah, we had to move it to the, that would have been to the north. Or, yeah, to the left.
Now you say we had to move it. Who do you mean by we had to?
So Savage is in control of the train.
They've got the box, the remote control box.
Yeah, I don't know how
However
they
they
did
do
it. Yeah, however they moved it, we got we kind of talked it over, like, is it possible to do that without it like just boom, boom, or whatever? He said, yeah, we can inch it. I said, that's all I want. And I said, I want it all stop, like everybody's in agreement, because this isn't something we normally would do. Putting two people under the rail car. So what I did was I tied that Curlex I was talking about. It's just like a long roller gauze. I just tied it around his wrist, right behind his thumb there. I don't know what I was doing exactly right there, if I was prepping that area to do all that or not, and then once we got into conjunction with, hey, this is what we're gonna do, I kind of scooted over a little bit. The thing was on there. They inched it back a little bit, and I was able to kind of pull his arm, back by his body here.
So they inched it back. You mean they inched it to the left?
To the left.
Yep.
Got the arm in. And then once, we were clear, everything was good. He wasn't spurting blood or nothing like that. Then they took the train and then they backed it off all her whole body.
Let me show you. A photograph that's been marked for identification as Exhibit 82. Sir, do you recognize that photograph?
Yes.
How is it that you recognize it?
Because I'm laying underneath it.
Because you were there, right?
Yes.
Okay. Is this a fair and accurate, it's a photograph of you under the train with Mr. Francis on the day of the incident?
Correct.
Is this a fair and accurate depiction of the scene as you remember it on March 7th, 2021?
Correct. And they got that they can pull up?
In 1 second, Your Honor, defense would like to offer plaintiff's exhibit 82 in evidence.
The objection?
Objection, Your Honor.
Now,
Sassel 82 is admitted.
all right, so they inched the train forward. you pulled his arm back from under, off the track.
Yes.
Correct? And then you were describing they were rolling it back the other direction.
Right.
Okay, is that what we're looking at here?
Yes, so if you look, this is that roller goes I was talking about is on his arm right there. That's what I wrapped around his arm, was able to pull, and I'm laying kind of like on his legs right there, basically. And so once I pulled that in, that's kind of the position we were in while they, took that car. And that's when we had the good communication, like, hey, let's not, anytime there's an all stop. We did it in a, controlled manner.
Okay, now as they're rolling the train off of Mr. Francis's arm and then back to the right or to the south, you're under the train with him the whole time?
Yes.
Okay. Now, while you were under there, did you hear or observe any sort of altercation going on, alongside the tracks?
No.
And at this point in time, have you seen Mr. Tyler?
No, I hadn't seen nobody else from Sasol besides Eric, and Eric was standing right outside because he's the one that handed me a few medical items under there.
Do you see any Sasol personnel in this photograph?
No.
All right, let's pull up Plaintiff's Exhibit 92.
In your own, to use the subpoena powers of the court to bring in those witnesses. Mr. Crawford, what are you doing? Are you on something
listening, Your
else?
Honor.
Are you on something else?
No, Your Honor.
I thought you were talking to somebody. I didn't know.
I'm looking at a file while I'm listening to you, Your Honor.
Okay, if you plead guilty, you're going to be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand me?
Yes, Your Honor.
You understand you're waiving your right to a trial by pleading guilty. You're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
All right. To the charge of possession of drug paraphernalia, how do you plead?
Guilty, Your Honor.
To the charge of attempted retail fraud, how do you plead?
Guilty, Your Honor.
Were you in the Home Depot store on Allen Road in the city of Woodhaven on February 3 of 26 at
Yes, Your
8:13 p.m.? Yes?
Yes, Your Honor.
And were you in possession of drug paraphernalia? And if so, what were you in possession of, and what did you use that paraphernalia for?
Yes, Your Honor. It was a water pipe for LSD.
All right. And did you commit the offense of retail fraud?
Yes, Your Honor.
So I'll ask you again, to the charge of retail fraud, how do you plead?
Guilty, Your Honor.
Did you attempt to take property, or did you take property that was offered for sale without paying for it, the intent to permanently deprive the owner, Home Depot, of that property?
Yes, Your Honor.
What did you take?
I didn't take nothing, but I was going to take some drill bits.
Some what? Drill bits?
Yeah, but I didn't take them.
Well, you must have taken something, right? Or not? You didn't put those in your pocket or conceal those initially in any way?
Yes, Your Honor. I did,
But you
but
didn't get
I
past
took
the
them
point.
out.
Hang on, slow down. But you didn't
Oh,
get past
sorry.
the point of, where did you put those?
In my pocket, sir.
All right. And then, but you didn't get past the register, I think is what you're telling me, correct?
Correct. Yeah, correct, Your Honor.
Somebody apprehended you in the store before you got
Yes, sir.
past the register?
Yes, Your Honor.
But at the time that you had put those items in your pocket, did you intend to deprive Home Depot of that property?
Yes, Your Honor.
Right now, are you on probation or parole?
No, Your Honor.
Anybody force you to plead guilty or promise anything to induce you to plead guilty other than a dismissal of the controlled substance charge and retail fraud charge?
No, Your Honor.
Okay, I'm going to find the pleas have been made voluntarily and understandingly. I'm accepting the plea to attempted retail fraud and drug paraphernalia. I'm dismissing the retail fraud charge. I'm also dismissing on motion to prosecute possession of a controlled substance. Why is he in custody and for how long, Mr. Crawford?
Your Honor, my client is in custody for another drug possession charge, Your Honor. It's pending. He's in the process of working out a plea agreement there. but it's based upon getting things at least resolved here, Your Honor. My client admits he's got a drug problem. He's trying to get into drug treatment. He's taking responsibility for that by pleading guilty now and to the other matter. He's been in custody now already, Your Honor, for 2 months.
That happened after this case or
Yes,
before?
Your Honor.
Yes, yes,
It
Your Honor.
happened, it happened before this case, Your Honor, but the warrant came out when I got picked up for this case. They picked me up from Woodhaven.
Do you live on Buff Street in New Haven?
No, I live in Rochester now.
Okay, can you give me the address?
591 Lesperance Drive.
You're gonna have to spell
LES.
that. Hang on. 591 what?
Lesperance, LESPERANCE.
Westbridge Drive in Rochester Hills, is it?
Yes, sir. 48307.
What kind of a bond does he have on that case, Mr. Crawford, out of Calhoun?
Your Honor, I'm not exactly sure. Sir, could you state what your bond is?
25,000
Cash?
cash.
Would the court consider sentencing my client to the time served?
This is a bad record.
Well, he's got a drug problem, Your Honor. He's been plagued with it for some time, and he's trying to get it in order now, but he doesn't deny it.
Yeah, I've never been. I do have a record. It's from the past. Like
Well,
way in
everything's from the past. Of course, you're not convicted of anything from the future yet, but you've got cases dating back to 06.
Yeah. I'm trying to go to.
You've had 20 years to get your act together and you're not doing it.
I recently went through a divorce a couple years ago and kind of fell off the deep end. I'm not making.
Well, you've been off the
excuses
deep
for my
end as far as
actions,
I can tell since 05 or 06. I mean, not many women are going to want to stay with somebody that's constantly in prison or jail. I mean, they're out there. They'll still do it, some of them, but this record's bad. All right, look, I don't want to sentence them. I want to look at this. I'm not going to order a pre-sentence report. Let me think of what I'm going to do here. When is Mr. Crawford here again, Heather? Are you here in 2 weeks?
I should be, God willing.
Yeah, Judge, he is our Woodhaven House Counsel.
I'm going to do sentence date April the 15th. You tell me what's best time for them to put him before a camera, if you know.
They seem to be, I just notified them on Friday of this date because I was notified he was in Calhoun County, and they got him on today, so they seem to be pretty flexible.
Well, what time do you want it? What time did you set this one?
8:30.
Well, let's do the same, 8:30. Boy, you got to get your life in order. You're only, what, 38? Pardon? 37,
Your Honor.
I'll just let it go with that. I would like to see, Heather, if we can get something just confirming he's in custody on that and has been for whatever length of time on that 25,000 cash bond. But I'm not ordering a screening. I'm not ordering a pre-sentence report. Good luck. We'll see you back here.
Do you want to put a bond on this one?
Oh, I forgot to do that. Thank you. See, that's a good thing, Mr. Crawford. You surround yourself with smart people.
Absolutely.
And then they can correct your mistakes.
Absolutely.
Good job, Heather. All right. I'm going to make it. Thank you very much for reminding me. All right. I'm going to give you a personal bond, $5,000. Don't take that the wrong way. I'm probably just going to end up giving him credit for time served. It sounds like he's got a lot of other fish to fry here.
Yes.
No alcohol or controlled substances. Not to enter any Home Depot, You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. Also, again, so no alcohol, no illegal drugs, no marijuana, cannot leave the state, cannot violate a law. You must appear in court as directed. You're not to go near Home Depot, any Home Depot. Do you understand that?
Yes, Your Honor.
We'll sentence you in a couple of weeks, okay? Thank
Yes,
you.
Your Honor.
Let's call him in,
Thank you.
Mr. Urick. All right, I don't have the file, Mr. Mays.
Yeah.
Is it up here? I'm sorry. I'm sorry. James Page, call in, Mr. Urick, though. James Lee Page Jr., 26W841132. Morning, Mr. Mays.
Good morning, Your Honor. William Mays, on behalf of Mr. Page. Mr. Page, state your name, please.
James Page, dude.
How you doing today, Mr. Page?
Yep. We're good, Judge.
Huh?
We're good.
He's got a little different attitude.
Well. So, Judge.
After this colloquy,
Mr. Owen.
I know, but he's gonna call him in. You know what, after he and I engaged in our little banter, when I looked at the complaint, I thought they were gonna have at the citation, I said, they might have a problem here. Then you filed the motion, and yes, so they're concurring in that. So just call him in, John.
Call him.
Your name?
William Durick, on behalf of the city of Blue Haven.
So you read their motion to, the defense motion to dismiss, you filed the concurrence, so you're gonna move the nollie process?
I am not moving the nollie process, Your Honor. I'm simply not opposing.
Okay, good enough. Case leave it on the judge, right? But I agree with it. Case dismissed. I'll just make a note. Prosecutor filed concurrence. I wish you well, Mr. Page. I hope you never get yourself in trouble again, but if you do, just try to be a little more respectful, will you please?
Sure.
All right.
Judge, destruction of fingerprints.
You can prepare those orders.
Will do.
And have him still, I want him still to sign that is approved, okay?
Fine.
You know, just on the
Like a
form.
police sheet or something?
No, just on the form approved by, and he could probably give you. Right,
Yeah, gotcha.
okay? Good luck to you, Mr. Page. Heather, take all of the bond conditions out, please. Okay?
Okay.
All right. Let's see here. Do I have Jonathan Hubbard here?
We could check and see if he's in Judge Hessen's courtroom because he does have a case with her also today. I'll call down there and check.
So would you check? Thank you. Bryce Isaiah Jacobs, 25W840947, A, B. Your name?
Right, David.
All right, so sir, you're charged with possession of a concealed weapon. And you're also charged with improper possession of a firearm in the vehicle. You have the right to a lawyer. Do you want one? Yes? Yes?
Yeah.
Yes, you're gonna have to answer out loud. Why weren't you here before?
I got the paper and I just forgot.
Forgot about it. How do you forget about court dates? I don't get it. I don't believe you forgot about it. I think you just didn't want to show up. Show some respect, will you please? Okay?
Yeah.
Respect, right? Who's that? Your dad?
No,
Your grandpa?
Yeah.
Tell him to have some respect, grandpa, okay?
Yeah.
No, yeah, you get to deal with me all morning. We're gonna set you up with a lawyer. And then the lawyer's gonna go ahead and talk to the prosecutor. And then the lawyer and you are gonna come in here, we're gonna handle the case, okay? All right, you got it? All right, good. Brian. Kiara Nicole Bryant Obi Acho, 26W841705 A, B, and C. Come on up to the podium. Yeah, right through there. Come on. You're good. Your name?
Here, Ryan.
You're charged with driving on an expired license, no proof of insurance, an expired plate. You have the right to a lawyer. Do you want one?
I'll pick on you.
I'll go ahead and arraign you and I'll let you go talk to the prosecutor then, okay?
Okay.
On March 7 of 26 at 12:55 in the morning, it is alleged that you did operate a motor vehicle on Allendale Van Horn in the city of Woodhaven while your license was expired. That is a misdemeanor. It is punishable by up to $100 fines, 90 days jail. Costs are all those 3 points. Do you understand that? Those are just the maximums. Do you understand that?
Yeah.
You have a 0-point civil infraction, no proof of insurance. You also have an expired plate, 0-point civil infraction. Do you understand that?
Yeah.
Did you sign an advice of rights and read and understand the rights?
Yeah.
If you plead guilty, you'll be giving up all those rights. And there will be no hearing or trial. Do you understand that?
Yeah.
You still wish to waive your right to a lawyer?
Yeah.
I'm entering a not guilty plea, $100 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You don't have to post it. Hang on, slow down. You don't have to post any money. And you're going to go talk to the prosecutor and try to resolve the case today, okay?
Oh.
Was there anything else that you wanted to say?
No.
Okay. So you just go out in the hallway. I'll have my court officer bring the file to the prosecutor and then you'll be called in by the prosecutor to talk to him, okay? Good luck. Smolinski. Which one does Ms. Voiles have? Ms. Voiles, which one do you have?
Robert Duchesne, Your Honor.
Have a seat right there, sir. Have a seat right there at the table. People against Robert Duchesne, 26W841-626. Your name, ma'am?
Good morning, Your Honor. Marissa Voiles, P86438, on behalf of Mr. Duchesne, whose presence I'm requesting to waive today.
Okay, so you met with the prosecutor. He's offering impeding. And,
That's correct, Your Honor. We would
and
plead
you're-
responsible.
They're gonna dismiss the stop sign, right?
Yes.
He's gonna drive better though, right?
Yes, he is.
He better. Okay, to the charge of impeding traffic, responsible or not responsible?
Responsible.
All right, I'm gonna accept the plea. I'm gonna assess fines and costs of $185, and that will be payable in a week. Can he pay by the 9th, you think?
Yes.
Okay, pay by April 9th. Thank you very much.
All right.
Thanks. Have a good
Thank
day.
you, Your Honor. You too.
Dennis James Smolinski, 26W841-702A and B. Your name, sir? Mr. Smolinski, you are charged with driving on a suspended and no proof of insurance. You have the right to a lawyer on the misdemeanor. Would you like one?
No, thank you.
I'll go ahead and arraign you then, and I'll send you to the prosecutor. It is alleged that you did on March the 5 of 26 at 9:55 PM operate a motor vehicle on I-75 southbound near West Road in Woodhaven. They think you had a suspended license. That is a misdemeanor punishable by up to 500 fines, 93 days jail, costs, or all of those in 2 points. Do you understand that? You just need to keep your voice up just a little bit.
Yes, Your Honor.
You're also charged with no proof of insurance. That's a 0-point civil infraction. Do you understand that?
Yeah.
Did you sign the advice of rights form here in my hand?
Yes.
You plead guilty to driving on a suspended, you'll be giving up all of those rights. And we're not going to have a trial of any kind. You understand that?
Yeah.
You still wish to waive your right to a lawyer?
Yes.
I'm entering a not guilty plea. $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You go out there, we'll take this file to the prosecutor. The prosecutor will call you in and you are all set. And then you, either way, you're coming back in front of me. You understand that, correct?
Yeah.
Okay, good luck. Gwen? I hope I'm pronouncing this correctly. Ty?
Please.
Team
Please.
View Gwen, 25W8366613. How you doing? Your name? Who's the interpreter here? I'm sorry. Your name?
My name is Kwan.
Can you tell me your full name?
Yes, sir. My name, full name is Kwan, last name is Nguyen.
Can you spell it for me?
Yes, Quang, and then Nguyen.
Are you related to her?
I'm her husband.
Well, I thought we got a interpreter, Heather. I got somebody's card here. This is Kim Ho and Olbris. Do you know anything about this?
I do not, excuse me, Judge, I do not know anything about an interpreter on this case.
Oh, I see what happened. I'm sorry. I got it. Okay. Raise your right hand. She's the defendant, right? You solemnly swear or affirm, will you interpret this for me? Do you solemnly swear or affirm that you will? Are you telling her this, sir?
Yeah.
Solemnly swear or affirm that the testimony you will give in these proceedings will be the whole truth, so help you God. What'd she say?
Yes.
All right, you can put your hand down. Since you were in court when I sentenced you on April 16th of 25, have you been arrested? Ask her that. Have you been arrested since I sentenced you on this case? What'd she say? Have you had any contact with the police for any reason since I sentenced you on this case? Case dismissed, motion to prosecutor. Best of luck to you. I wish you well.
Thank you.
Thank you. Good luck. What do I have here? Is Mr. Hubbard in the other courtroom?
No, he was not.
Why am I shocked that he didn't show up today? I mean, it was just pretty obvious that wasn't going to happen. Alexis Rachel Leanne Syler, 26W8406, 18A B. You all right?
Yes.
What happened? You hurt your foot? All right, what's your name? You're charged with operating with the presence of drugs and resist and obstruct an officer, and you have the right to an attorney. Would you like one?
No.
Are you sure? I think you should get one on this. I'll be glad to appoint you one.
Sure.
Is that okay?
Mm-hmm.
Is that a yes?
Yeah.
All right. We'll give her a lawyer, John, on this one, okay? Thank you.
Let's see the hall.
You're gonna have a seat right out there and we'll set you up. Good luck. Do you what do you have, Mr. Counsel? What do you have?
Good morning, Your Honor. I have Reno, Renato. Last name is Capote, Capato.
We hear that.
I'm looking at this one because John did come with this one this morning. But we had it scheduled, but then it was paid, so it kicked it off the docket.
Hey, Heather, I can hear you.
Yeah, this is the one I'm referring to, Judge, is that John came to me with this one this morning. It was on our docket, but then the defendant paid it, so it kicked it off the docket. I believe this is the one. I'm trying to find it again.
Did you talk to a prosecutor on this?
No, Your Honor.
Did you hear what she said? She's saying your client paid it.
Well,
I don't
hopefully,
know-
it's
I
my
don't know
understanding.
anything about it. I'm gonna let you guys figure it out, okay?
Thank you, Judge. Thank you.
I will keep chatting with you, Counselor.
Michael Nixon. Michael Charles Clifton Nixon, 14B, 75335A. And then I have a whole bunch of other ones, 14B, 75335B, C, and 13B, 108365B. What do you think?
Dismissed, go off.
I'm sorry?
Dismissed, go off.
I'm not amused. Tell me your name.
Oh, yes.
You haven't been here on these. I mean, I realized you were here a couple of weeks ago for arraignment, but boy, I can't believe somebody let this go for 12 years. You met with the prosecutor on 335A. You're going to plead guilty to driving on a suspended, true?
Sorry.
If you do that, the possible penalties are up to 500 fines. You didn't have a lawyer today, did you?
Yeah, Mr. Crawford, I call his eyes. There he is. Lawyer on the Michael Crawford, representative, defendant.
All right, so I didn't realize you were on this one. These are up to 500 fines, 93 days jail, costs are all those on the suspend charge. Do you understand that?
Sir.
And then we're going to conduct contempt hearings on the B and C files unless you tell me he's got the money. I'm not amused at all in the least with him.
He does have the money, Your Honor. It's in the safekeeping of the court by way of his bond paid.
Good, good. And then what are we doing on the case out of Brownstown?
So, Your Honor, there are two cases. He's going to be pleading guilty to the first case. I'm sorry.
Boy, they're getting awful nice back there, huh?
And the second will be dismissed, Your Honor.
That's the one out of Brownstown, right?
Correct. They're both are both. But they're both suspended on.
Yeah, you're right. All right. All right, so if you plead guilty on 14B75335A, the B file. One three B 108-365B will be dismissed. And then we'll deal with the contempt charges. Do you understand that, sir? I can't hear you. Words you just said. And you understand you plead guilty, the possible penalties again on this are up to 500 fines, 93 days jail. Costs are all those 2 points. Do you understand that?
Yes, sir.
All right. Again, today, did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial. Do you understand that?
Yes, sir.
To the charge driving on a suspended license, how do you plead?
Guilty.
On December 16 of 2014, were you operating a motor vehicle in Pennsylvania east of Dixon, Brownstown at 7:07 a.m.?
Yes, sir.
Was your license suspended?
Yes, sir.
Are you on probation or parole?
No, sir.
Anybody forced you to plead guilty?
No, sir.
Please accept it to that charge. I'll go ahead and dismiss on motion to prosecutor 13B 108-365B. And I will send you this. And I will apply the bonds to the extent he has them for the remaining cases. He owes 428 plus 362, which is 790. Plus 296, so he's up to $1,086, and then he's gonna have this one to pay. Does he have bonds to cover all those?
His bond should cover those, Your Honor. You paid $1,200, Your Honor. So if I did the math, I believe he got.
Yeah, but he's still got this one for me to sentence him on. Right?
Well, that's true. But contempt matters. For however you sentence him, he's gonna need a short payment arrangement that having in the day when he gets paid tomorrow. We'll discuss that. The $1,200 wiped him out to run when he gets paid tomorrow.
Why would you take this long? Come and take care of your business.
Oh, I don't have no excuse,
I can't hear you.
I said, I don't have no excuse. I apologize.
It's not my favorite answer, but that's a good answer. My favorite answer would be for you to show up on time, but at least you're not telling me it got lost and. Go ahead. What else do you want to say?
Well, nothing, Your Honor. Again, my client is admitting he was wrong here. He's learned from it. Financial lesson. He's just trying to get his license in order to move forward, keep his good job, keep moving.
Where does he work?
He work against the
FHI,
What do you do there?
close the dock,
Okay. How old are you?
41.
All right. Anything else?
No, Your Honor. He just like the opportunity to propose a payment arrangement. He'll take care of this. It's too busy.
100 fines, 250 costs, 75 victims' rights. $50 justice assessment, 475 for 90 days on the suspend. And I just want to make sure. Yes, it is in his name. He has 6,010%. So he'll need, so this will satisfy this case and he'll have an extra
He does have,
75.
he does have clearance fees on these cases also, Judge.
Right, so he had $540 to apply since it's a 10% bond. So he has 65 left on that bond, and then on the other bond, he's got 540. So he has in total 540 plus 65, plus 65, which is 605. So am I right, Heather, that on 335B, he owes 428?
On 335B, yes, that's correct.
Does that include the clearance fee?
Yes, it does.
So he is going to pay today on this one $383. So that won't cover his clearance fee. He should have then, after that, he should have 200, wait a minute. Should have $222 left. And on that one, on file 365A, he owes 296, right?
That is correct.
And that includes the clearance fee?
Let me pull that up. Yes, it does.
All right, you pay 223 now on that. You still owe the clearance fee on that, and you're still gonna owe the clearance fee on the other one. That, I think, is gonna wipe him out. So now he's got, on the other case, he owes 362, which includes the clearance fee. So he's gonna pay $317, did you say tomorrow?
You can pay $300 tomorrow, Your Honor, and you can also pay $300 every 2 weeks thereafter. That's when he gets paid.
He won't need that. So he could, I'll tell you what, you pay 300 tomorrow on file 335C, and I'll waive the other $17 or $18.
Thank you, Your Honor.
But still has to pay the clearance fees on all these. So then he'll have to come back and pay clearance fees of $45 on each of these. Okay? If my math was in there, Heather, don't leave. Let's make sure we got everything right. I think I did it right, though. Okay, do you understand? Go down and talk to my judicial clerk. I think we got everything under control here. Thank you.
I will need those files, Judge, just to double check also.
I got it.
Thank you.
Justin Herren. Justin Herren. This is Justin. Tyrick Herren, 26W841-783, A, B, and C. Your name?
Justin, how
you doing, Mr. Herren?
I'm good. How you doing, Your Honor?
Not bad. You're here on a driving on a suspended. You also have 2 civil infractions, no proof of insurance and expired plate. You have the right to a lawyer. Do you want one?
No, thank you.
I'll go ahead and arraign you and send you to the prosecutor. It is alleged that you did operate a motor vehicle in the city of Woodhaven. On March 7 of 26, they think you had a suspended license when you were driving that vehicle on Western Allen at 11:02 p.m. That is a misdemeanor punishable by up to 500 fines, 93 days jail, costs, or all those in 2 points. Do you understand that?
Yes, Your Honor.
You're also charged with no proof of insurance and expired plate. Do you understand that?
Yes, Your Honor.
Did you sign the advice of rights and read it and understand it?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial. Do you understand that? You have the right to a lawyer. Do you still wish to waive your right to a lawyer? Not guilty, pleas entered, $500 personal bond. You cannot leave the state without consent of the court or violate a law. You must appear in court as directed. We're going to take this file to the prosecutor. You go out in the hallway. Prosecutor will call you out, and you can talk to him, and then you'll come back in here, okay? After you've talked to the prosecutor, all right? Best of luck.
Judge?
Yeah.
I'm sorry, I'm speaking with the attorney here. I did find that case. The defendant did pay it. It was just an impeding traffic ticket.
Oh, So you're all set, counsel.
Thank you, Your Honor. You have a wonderful day to you and your staff. Thank you, Judge.
You too. Thanks a lot.
Take care.
Whale Mohammed Alonzi. 25W838813A and G. Who's the lawyer on this?
Arabo?
I mean, this thing's been going on. Call in the prosecutor. John. People against Whale Mohammed Alonzi, 25W838813A and B. I don't like this one. Your appearance?
William Urick on behalf of the people of the city of Woodhaven, Your Honor. To my detriment and regret, counsel had emailed some form of a family emergency arose for counsel. He actually had been telephoning the court very early this morning, finally got through the conference room, and I indicated to him that I would do my best to endeavor to see if the court was willing to adjourn this matter. This was one, Judge, where we adjourned for the defendant to perform remediation in various courts to compel us to do a allowing. And apparently that has been achieved. So at the very next or final court appearance, this should be resolved quite easily.
Told us on March 4th, he had an emergency matter to address.
I was not aware of that.
That was in the stipend order for adjournment. Defense counsel has an emergency matter to address and cannot be present in court tomorrow.
Interesting.
Additionally, defense counsel and prosecution require additional time to resolve the matter. All parties are requesting an adjournment greater than 3 weeks out. We're grateful for the court's understanding and accommodation. I set it out more than 3 weeks. He was arraigned on February 4th. How many emergencies can the lawyer have unless it's an ongoing or the same thing? Heather, I want you to call the lawyer and I want you to tell him I'm setting this for a jury trial and I'm setting it for a final pretrial. Give me a jury trial date by the end of April. Eric, how about 4 weeks from tomorrow or Friday?
Okay,
No, we can't do that. I have court to school program, right?
that falls on a Thursdays.
Oh, the court, that's on a
Court to
Thursday?
school is Thursday.
We have law day on the 1st. What am I
Yes,
thinking?
yep, that would be law day.
May 8th, we're gonna set a jury trial date. And that's gonna be at 8:30, and I'm setting a final pretrial with no more adjournments. So he said he had another adjournment, he had another emergency?
The phrase was family emergency.
Final-
It didn't necessarily sound like a legal emergency, i.e. a conflict in another court, so much as it sounded like something related to health, but
Fine.
I didn't ask too many questions.
I get it. April 15th at 8:30, no more adjournments. I want you to remember this case, okay?
It's on my mind.
If you would, no, I wouldn't mind if you emailed him and told him, Judge, set it for April 15th, no more adjournments, he said, so be present, okay?
Very well.
Thank you very much.
Thank you.
Thank you. Newsom. Timothy Edward Newsom. 18W21475A and B. Is Timothy Newsom here? Timothy Newsom?
He's on Zoom, Judge. He's coming in now.
Okay. Your name? Your name?
Timothy Newsom.
Where do you live, Mr. Newsom?
I recently just moved out to Highland, Michigan.
I'm not excited about you appearing by Zoom when you haven't been here in 8 years, 7.5 years. You with me?
Right.
Did somebody at the courthouse give you permission to appear by Zoom?
Yes, I called about 2 days ago and asked the request the Zoom.
Well, why
I
am
did
I going
not-
to accommodate somebody that, and that's fine, Heather, if you did.
I was gonna say, I did not judge. I'm not sure who you spoke with.
Who'd you speak to?
I didn't get a name. I just called the courthouse.
I'm not excited about this. You know that? You didn't show up for 7.5 years. Was there a reason for that?
Honestly, I have no excuse.
Good. Adjourn arraignment and pretrial. We're going to adjourn it to the 15th, defendant to appear in person. And I'll set it for April the 15th. And we're going to give you a little more time since you're coming so far away. I'll give it to you at 10:30 in the morning, okay? But you got to show up. I don't mind accommodating to the extent I can, but that's what I'm going to do. So you'll have to show up in person. We'll see you here then. Best of luck. Thank you. People against Manion Express LLC, 26W84-18798. Yeah, and I have to send him away too. Your name?
Alan Gustav,
Can you spell your name for me?
ALIN. First name and last name is PUSTA.
Are you the owner of this company?
Yes.
You're the president?
Yes.
I can't let you appear on behalf of the corporation. I'm sorry. I just can't. It's a misdemeanor and this is not my rule, but I just can't let you appear. You can't represent the corporation. You're gonna need a lawyer, okay? I'm not trying to get lawyers' business, but this is all I can do.
So only, I have a question. I think the officer who wrote this ticket, was he typed the wrong plate number in the truck. I don't have a truck register on that,
You're gonna have to talk to your lawyer about that, okay? I gotta have you hire a lawyer.
Ms. Nicholson's here on behalf of the state of Ohio. There was a report that was issued by Dr. Ledgerwood. The date of the report is March 31st, 2026. Has everyone had an opportunity to review that report regarding competency?
Yes, Your Honor.
Do we have a stipulation to the report?
We'll stipulate to the report. Yes, Your Honor.
All right, so based upon Dr. Ledgerwood's findings, the court does find that the defendant is competent to stand trial, and we will proceed accordingly. It's my understanding, Mr. McKenna, that your client wishes to waive his right to trial by jury.
Yes, Your Honor. I'd like to set this for a bench trial.
Okay. Mr. McDaniel, you understand, first of all, that you are entitled to have your case heard by a jury of 12 people. And what would happen then is the state would be required to present sufficient evidence to convince each of those jurors beyond a reasonable doubt of your guilt, or they are required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yeah, I think I would rather do that, Your Honor.
You'd rather have a jury trial?
Yeah.
1 second, Judge.
It's 12 people that are saying, Your Honor.
He wants, I guess he's changed his mind.
Okay, do we have a time issue? Can you tell?
I'm looking, the speedy trial, if the time had not been told, would have run March 24th. So I'm looking to see, this isn't my case, so I'm looking to see when the,
So it's going to be about 30 days, I'm guessing.
it was filed March 2nd, so I think.
So about 30 days. So April 24th?
Approximately, yeah. Yeah, I have murders. I'm gonna be a little bit for jury.
That's fine.
We'll have to wait time.
I'm gonna, okay. Let me pull that up.
Oh, the competency was filed February 11th, so there might be a little more time. I'm gonna do the calculation right now.
How does your schedule look? Let me just pull up my calendar real quick too. So if we're looking at towards the end of April, how does, oh crap.
I think the court may have closer to 45 days.
Is April out completely, Mr. McKenna?
I could do, like, I assume this will be 3 days. Or yeah, I don't know.
I have no idea.
What about April 22nd?
How about April 23rd? Oh, hang on. Oh, you think it's just 3 days?
I pick a jury. I mean, it's literally a family squabble.
I'm thinking more like 1 day.
Oh yeah, I'm being generous. I mean,
It's never going to go 3 days.
Probably we could do the 23rd and 24th or 22nd, 23rd.
The only problem with the 22nd is I have Veterans Court that morning, so we wouldn't be able to start until probably about 11 o'clock.
That'd be fine with me, Judge.
Start at 11 on the 22nd.
Yeah, just get the jury picked and then it has to go the next morning. It's up to you. I'll defer to the court.
I don't have a problem with that. What I'm trying to figure out though is Jennifer's not here and I don't know. All right, let's do that. Let me look into that. She's out till Monday. So if we do 2 days, jury trial beginning 4/22 at 11. I can have the jurors report at 10. And then we could probably get underway by 10:30, 11.
That'd be fine.
Okay. Let's try that. And that would take us that Wednesday afternoon and then Thursday, Friday that we have the 12th district seminar, but I don't have to go to that. So we have Friday available too.
I think we'd probably wrap it up on Thursday anyways.
Okay. All right, let me do that. I'll check with, have Jennifer check. And my only hesitation is whether that's sufficient time to summon in a jury. It's 3 weeks.
So
3
that's
weeks
it.
from
1,
3 weeks
2,
from
oh.
today,
Oh, I see.
right?
Yeah. Well, I'm available.
Okay, I'm going to hold that date for now, and then we'll just go from there.
That sounds good.
All right, thank you all.
Thank you, Judge.
Lawyer, I can't let you appear on behalf of the company. I just can't. I'm sorry.
When can I get a lawyer?
Pardon?
Get myself a lawyer?
The company, you have to get, somebody for your company has to get a lawyer. I can't let you appear on behalf of the corporation. I'll give you April 15th at 10 a.m. I'll do that for you. And you can, you have to go hire a lawyer before that.
Okay.
Okay? I'm not trying to give you a hard time. I just can't, I can't allow that. I can't do it. The rules don't allow me to do it. All right? Best of luck to you. See you back here. Thank you. Jonathan Hubbard here. He's still not in Judge Hessen's either, right?
Not as far as I know. I checked with the court officer there and he was not in there.
Well, I'm calling my case, which is 25W838-675. Defendant failed to appear. Yeah, this guy, I just sense bench warrant issue, bond to be forfeited online, 10,000, 10%. I just knew when I read this morning, he wasn't gonna be here. I'm gonna send, Judge Heston's gonna have to call hers and do the warrant. I don't have that file, but I also have 268840-293. Defendant failed to appear, second miss. Besides that, it's a willful intent to delay adjudication. And as long as he's gonna play games, 7,500, 10% on this one. Defendant failed to appear, this is the second miss. Bench warrant, forfeiture, 7,500, 10%. Do you know who these?
Do you have a Jacobs file?
Jacobs?
Yeah.
I didn't break out. But you just not to look on the face.
There to call that.
Oh, I did?
Where's the guy at? Mr. Baldwin just walked in and said the guy. You what?
He was supposed to be set up with that.
What are you two here
About
on?
a half miles out of the courtroom. What did you have fun? I'm here for Deerfield State Sentence.
He's a civil case at 10:30.
She's
We're back on that again?
I think he was paying fine.
I was.
I think it was a deadline to pay it.
Hang on, what?
I believe it was a deadline to pay it. I have double.
All right, Eli, come on back. I've been wondering where you were. How you doing?
Been a few days.
I know, but I was thinking about you this morning.
Oh, look at that.
Not bad.
Yeah.
That doesn't mean he didn't file.
Did you find? Deerfield Estates versus Emilio Castillo, 2600528.
Good morning, Your Honor. For the record, Daniel Lampum, P35797, appearing on behalf of Deerfield Estates.
How you doing?
Doing okay.
I didn't make you come, you didn't take me as making you come in person, did you?
No, I'm here because my better half and I are catching a flight from Metro after we're done.
Oh, nice. Where you going?
They would kill two birds with one stone.
Where you going?
My mom lives in Chapel Hill, North Carolina.
Nice.
Flying to Raleigh.
Very nice. Your name, Mr. Castillo?
My name is Emilio Castillo.
Did he file a motion to set aside default judgment? I thought I told you to file a motion to set aside.
I haven't seen one, Your Honor. That doesn't mean he didn't file.
Did you file one?
I did not. The court date was set and I was supposed to come back April 1st. We said.
Heather, can you have Jennifer come on here, please, or somebody from Civil? Look, your office started a termination of tenancy action. Are you aware of that?
I am aware of it.
And I'm convinced the guy has gone far enough to clean up the property. He's got the money. Did you pay the money? How much is owed right now?
As of this morning, Your Honor, the April's run added in $3,168.91.
Do you have that? All right, so here's what I want to do. You're not really running late or anything, are you? Can you read a set aside? Heather, did you call Jennifer?
Yes, Judge, I did ask somebody to zoom in.
So I'm hoping that you'll go down and just prepare an order, have them give you an order, setting aside the default judgment. And he can pay you right in open court here, and you can file a voluntary, just stip an order to dismiss. Is that fair?
Well, the problem, Your Honor, is that this is a chronic slow pay. The last time that Mr. Castillo was close to being current was October. So we're going to run into this situation again. And my client did not authorize me to set the judgment myself.
Go down and
if he pays and the court allows him to, even though he didn't pay timely pursuant to the judgment, I think what he might be entitled to is the satisfaction of the judgment rather than vacating the judgment.
It was a valid reason. Why didn't you listen to what I told you and file a motion to set aside default judgment, Mr. Castillo?
I didn't understand.
Well, you should have asked me. What do you mean by that?
I did. You said it. I said it. I did not.
Heather, I'm not gonna have much. Where are they? I mean,
Hold on, Judge. Let me go ask again. Here, Linda's coming on right now.
good. Linda, good morning. I'm gonna send down Mr. Castillo. I don't know why he left without filling out a motion to set aside default judgment. Waive the fee form.
Okay, I'm
Let him
sorry,
fill
Your
it out,
Honor.
And I'm gonna hear that now, but do it quickly. You gotta listen to what I'm telling you. And you can't get behind on the rent again. So go fill that out real quick. What time you gotta be out of here?
My flight's not till 3:20.
Oh, perfect. Go fill out your motion to set aside judgment, and then we'll start with that. I'll set aside the judgment. He's gonna pay it. And then the case was gonna be dismissed, right? I mean, you don't have a problem with that. You're gonna agree to dismiss the
If
case.
he's able to demonstrate good cause and meritorious.
All right, okay.
Well, I just thought, you know what the court rule says.
I know what the court rule said.
So, and then
I don't remember why he told me, go fill out your motion, will you? You're gonna get your money, and he's gonna stop doing this. That's what he's gonna stop doing. I get it.
I think you're half right. Off the record,
Yeah,
one of them.
yeah, go out. Right.
My biggest fan and biggest critic. I like that.
Well, nice to meet you. How are you? I enjoy that.
Nice to meet you.
She does a good job.
I
Enjoy
enjoyed,
professionalism. I really do.
this is my first time, we've been married 31 years that I have seen him in action.
Yeah, good.
Yeah,
It's good. He does a really nice
I
job.
said you're a great guy.
Well, I don't know about that, but have fun and chat together today.
Thank you so much.
That's good.
Nice to meet
Well,
you.
you too. You too.
Mom's 91 year.
What's up? My mom's gonna be 91 in a few days.
Good for her.
It's crazy. Good for that. Good for your mother. Take care. Thank you. All right, Justin Herren. Justin Herren. At 267-841-783-A, B, and C. Your name?
Justin Herren.
All right, I'm gonna give you 30 days, but that's it, okay? You're gonna have to take care of this, all right?
Yep, I got you.
I'll adjourn this to April the 29th. We go on Brownstone and Woodhaven here are in here every 2 weeks, assigned to different judges. So I'm gonna give you April 29th. At what time, Heather?
We can do 8:45.
8:45. Do you know what courts you have to go to? You got a warrant out of our court.
I was just talking to the prosecutor and I had a court here maybe last week and I resolved that with the lady judge. Just,
Judge Hess,
Yeah,
the lady judge. Why do guys say that? Why do
I
people?
forgot her name.
All right, okay.
Yeah.
Well, this printout was run on March 9th, so you might have make sure that he has that one taken care of.
That's taken care of.
All right, good. Then go down the hall, get your notice, go over to the other courts, and we'll see you back here on the 29th, okay?
Okay, that's right.
Have a great day. Thanks. Good luck. Do I have, who's in jail there, Heather? What's that?
I
on?
have no idea. The room has been, I just see an empty room since I pulled them in to see who was there.
What's that? Sir.
It may be Kenneth Hurd. I do have another felony arraignment. I have Devon Smith, who's in a breakout room. That one might be Kenneth Hurd, because I have another felony arraignment at 10:30 also.
Sir, can you, it looks like a head, the forehead. Can you stand up?
Oh, I do there.
What's your name? Oh, you're
He's
muted. You're gonna have to call a guard or unmute if you don't know how to, unmute, you're gonna have somebody come and unmute. I don't know who you are, and what you're here for, so we'll figure it out. But do you know how to unmute the device? Up and down or side to side, do you know? All right. Is muted. And what's your name, sir?
Kenneth Hurd.
Kenneth Hurd?
Yes.
And that's for what, Heather?
Yes, he's here for a felony arraignment.
Has he talked to a lawyer yet?
No, he has not. So I will put him in a breakout room.
It's automatic unmuted. It was muted. It was accidentally unmuted.
Heather, are you putting him with Baldwin?
Yes, he can also go with Baldwin along with the other one.
Perfect.
Which Amy found that, or we found that file. Amy's taken that one down.
Okay. Has he filled that out yet, Linda?
Your Honor, he's working on it right now, okay?
Okay.
Sorry I wasn't here.
No, it's okay. He should have filled this out before he left last time. I don't know why he didn't. I told him what to do.
Okay. Yeah, he's working on it.
Okay, good enough. Thank you.
You're welcome.
So that gentleman has heard. He's going to meet with Baldwin. Sir, in the back, what are you here on?
Deerfield Estates, Your Honor.
Okay, you're on Deerfield too. Okay. Was that a manager or something?
I'm the Director of Community Operations.
Okay.
Our manager had a flat tire.
Okay. That's not fun.
No, it's
Um, well,
It's gonna be a few minutes for Mr. Baldwin to talk to him.
yeah, so as soon as I get Mr. Castillo here, Mr. Landsman, I'll come out, okay? Thank you. Stay seated, everybody.
Yeah, he said. So we got.
Your name,
Yeah, let's see.
Once again, for the record, Your Honor, Daniel Land, P357.
all he said was have payment. I thought you gave me another excuse as to why you didn't.
Oh, no, we did. I was advised not to, pay during that time period, because I was being evicted and,
You were not advised by me, you were advised by, hang on. Part of the issue here was, as I recall it, was that there was a termination of tenancy action. So your client wasn't going to accept the payment, I think. Is that not what I heard, or am I misunderstanding?
we went through terms, an eviction due to rent. Judge Essen ordered me to pay on the 26th of December. I paid, judge was not, payment was not applied till somewhere around the 3rd. Because they were waiting on word from the court of the process we just went through. So when I contacted the attorney, they had advised me to not pay until judgment.
Your Honor, and I think, just so the record is clear, I think Mr. Castillo got bad legal advice. Because pursuant to MCLA 600.5779, when a termination case is pending, the tenant is still required to pay. So I'm not sure why he was given the advice that he was given, but the advice was incorrect. I'd also note, just so the record is clear, Mr. Castillo last had a zero balance in December of 2024. He came close in October of 25. He came close again. Well, he hasn't been close since then.
Yeah, but let me go back to what you just said. The landlord cannot accept payment when they've started a termination of tenancy action.
No, the law actually allows it. 600.5779.
Well, wait a minute. What about the Park Forest case? That was never, was it?
Park Forest does say that if the landlord accepts rent and leads a tenant to believe that
Right.
that's going to resolve things.
You have to take your hat off, sir.
But with that being said, 600.5779, which applies to manufactured home parks. So
Okay.
the termination action is pending, tenant is still required to pay.
Because there's a little difference in the,
And I
he owned the property is the point. He-
Park Forest, I believe, was an apartment complex.
Right, right. Okay. Well, look, I'm gonna set aside the default judgment. He's got the money to pay,
May I inquire whether it's in certified funds?
I have it in my bank right now. It's in cash and I can turn it into money orders.
did you bring it with you
I have it right now. I can
in
withdraw it.
cash?
I have,
Wait a minute. Did you bring it in cash?
Not bring all the way to cash, no, I have it on the other card in my bank account right now.
You don't listen to me very well. Come on. I thought you were gonna bring the money with you. I don't want him sitting around here. Why aren't you listening to me? I mean, I've gone out to the property and looked at it twice early in the mornings with my court officer. How are you gonna take care of this now? When can you be back with the money?
So
Well, what's immediately?
go obtain the money orders and come right back.
I don't know where you're gonna get the money orders. Where are you going?
I'm going to go to Walmart, get money orders, I can go to the bank.
You can't get the Walmart on Allen Road, man.
No.
So I don't want this guy waiting around here all day.
I can be back
Within an hour?
within the hour.
It's 10 minutes to 11 right now. What time are you gonna be back?
Be back in.
You don't listen very well. You do not listen very well. I told you to bring the money with you. These guys got better things to do. I'm setting aside the default judgment. But you don't have the money to pay right now, and I find that you owe the money. How much are you asking? I'm gonna give you a judgment again. That's what I'm gonna do, and we're gonna start the writ date over.
Very well, Your Honor.
Give me your-
Current balance is $3,168.91. And I believe that does not include the court costs. I'm checking now. No, it does not include the cost of 187.07. So that's going to take us to $3,355.98.
I'm giving them a judgment. I'm giving them a writ date of April the. It's gotta be the 13th. So I'm setting aside the default judgment. Judgment. Money, possession judgment will enter. 3355.40.98, and the writ date will be April 13th. You got to get him the money. I don't know why you don't listen to me very well, Mr. Castillo. I mean, if you didn't know how to fill out the motion, you should have inquired. You could have inquired of me. I would have explained it. Then you could have inquired of the civil department. Instead, you left. I told you to bring the money here. You come here with not enough money. I mean, you got to listen better and stop paying these guys so late. That's it. Thank you. You're going to prepare a judgment today?
Your Honor, we will file a judgment. Call my office right.
Thank you very much. Have a great time.
Thank
Enjoy
you.
yourself. Nice to meet you. All right. Kimberly Marie Galasha. 25W835-356. Is Mr. Crawford out there?
He's not on Zoom, Judge.
Where is Kimberly Marie Galasha?
He's not answering.
Is she in the building, Heather?
She has not been on Zoom, Judge, so I would say yes.
All right. Galasha, Gallotia.
And see,
Looks like the warrant was canceled today, so she must have come in. Hello? Hello? Is this Vince or Will? Vince, will you do me a favor? Find Mr. Crawford, tell him to come in. And if they're in yell out a name, Kimberly Galasha, she needs to come into the courthouse. It looks like she was here. We canceled the warrant this morning. Okay, thanks. Bye.
She must be walking.
Yeah, I think she is a walk-in.
Yeah, and if she was, I did not get the file, Judge, so I apologize. I did not know.
You're
this name.
fine. No, I think she wants to come in because the warrant was canceled. Mr. Crawford have another case of ours.
He's working on a couple, but I don't know what he's doing, so he can want to answer your phone. He's got Brian Smolinski. Here.
Mr. Crawford in there? Okay. All right, thank you. Thank you. Bye. He said Mr. Crawford just left there.
It's just sitting right next to him. Mr. Haynes is ready on these two.
Did you have fun?
I did.
Good.
Did you?
I wasn't involved. Yeah,
That's great.
good. Glad to hear that. All right. Are these
Yep.
people against Bryce Isaiah Jacobs? 25 W840947A and B.
Yeah, good morning. This is with me, Bryce Jacobs, and the reports in randomly full readings.
Okay, sir, is that what you want to do?
Yeah,
Your name?
Bryce Jacobs.
All right, so I'll enter a not guilty plea. We have two charges here. Possession of a concealed weapon, so I'm indicating he stands mute on both. We have possession of concealed weapon under count 1. I understand he's going to plead guilty to that. That will be under the Home Suitable Trainee Act. And then as the count 2, that's going to be dismissed, true?
Yes.
Is that what you want to do, sir?
Yeah.
All right, if you plead guilty here to this, the possible penalties are up to 500 fines, 90 days jail, costs for all those. I'll take your plea under Haida. I'll set terms and conditions after I order a pre-sentence report. If you're compliant with those at the end of the specified period, the case would be dismissed. And it would be a non-public record only. Do you understand that? You just sign, read, and understand and advise your rights form here today. If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that? All right. To the charge possession of a concealed weapon, how do you plead? On November 29 to 25 at 4:10 in the morning, were you on Westner, Godeth, and Woodhaven in a motor vehicle?
Yes.
And did you have a concealed weapon?
Yes.
That was not a locked container and it was under the seat. Is that true?
Yes.
Loose?
Yes.
You didn't have a concealed pistol permit, correct?
Yeah. I didn't.
Are you on probation or parole? You got to answer for me.
No.
Anybody force you to plead guilty?
No.
Okay, I'm gonna accept your plea to that charge under count 1. I'm going to dismiss count 2 on motion of the prosecutor. I'm gonna order a pre-sentence report. And then we'll have you back here for sentencing. Let me just double check something here. Yeah, give me 1 second, please. I never set bond conditions. Yeah. Were you ever printed on this case? You weren't fingerprinted, were you?
Yeah, I was.
No, let me just double check. Heather, can you double check that for me? I don't see the CCH in here. I see his traffic record. It's probably in the other file. I'm
Yeah,
gonna
I'll run it
continue your
under.
bond. I'm gonna continue your bond to $300 on the 9478 case. I've dismissed the B, so I'm transferring that over to the A file. So essentially, you're gonna have 5,010% on the A file. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No contact with prosecution witnesses. You're not to possess firearms. You're not to possess dangerous weapons. Do you understand all of that?
Yes.
All right. Okay, so I'm ordering a pre-sentence report. Those are your bond conditions. Again, you can't leave the state. You understand that, true
Yeah.
as well?
Yeah.
All right, I'm gonna give you a sentence date. When will that be, Heather?
We could do April 15th at 8:30.
All right. Good with you guys? April 15th at 8:30. How long are you gonna be here, Mr. Haynes?
My last day is May 15th.
Can you do a court to school for me at Trenton High School? I'd love to have you.
What day?
April 30th. Is it the 30th?
Yes. at 9 o'clock.
No. Okay, we'll do April 15th then. Go ahead.
Judge, I'm sorry, I just ran his record and I'm not showing that he was printed.
We'll do April 15th at 8:30. And you have to go over to get fingerprinted and photographed. I don't have an order. I'm writing it on the bond sheet.
They did that to me 2 times. They fingerprinted me.
Call over there, Heather, make sure something didn't happen, but you otherwise, either way, you're gonna have to go over there unless she tells you you don't have to because there was a mistake and they have the prints taken. So you're gonna have to be over there by 1 PM today, okay? Do you understand that?
Is your print order still in the file, Judge, also?
Do not see it.
Okay.
I do not see it, but let me double check the other one. No, there was never a print order put in here, I don't think.
Let me see if there was one printed too. That'll tell me.
So you'd have to go over there by 1. If she tells you you don't, that's fine, okay? And then she go down the hall, get your notice, and over to probation where you will be interviewed, okay? Pre-sentence report. Anything else? Good luck, sir. Thank you. Did you ever find Galasha?
She's not in the building. People check in with me, so I don't know what. I never checked in the front.
I don't know what happened on that.
Yeah. One more, right?
You got something?
Just got it. What's that?
He's filed,
I put one more thing.
but he's filed the bond. Do you need to review this now before I do anything? So do you
Want to
want
speak to the prosecutor?
Okay. Yeah. Okay, I'm bring cards down for you.
Okay.
Okay. I know that he's got to go get the $25 fee and bring that back, but I just didn't know if you need to.
Okay.
Okay,
Thanks.
yep.
Yes.
Yeah.
Thank you. Kimberly Marie Galash, 25W835356. Your name?
William Burke on behalf of the city of Woodhaven, Your Honor.
I'm confused. She hasn't been here. We canceled the warrant today. I've been calling her. She isn't here. You filled out a
Is
dismissal.
this the loitering in a controlled substance house, Judge?
You said controlled substance tested negative.
Correct.
Now
This
we
is
press.
off the docket. The defendant is not here. The warrant has been already wrong, I believe, what I understand. So this, in essence, is a housekeeping motion to null and cross, Judge.
Okay, good enough. I thought so, but I didn't know, how did the warrant end up being canceled? Because you asked for the file?
That I do not, I think that was correct.
Okay, that was the only thing that confused me. Your motion, case dismissed.
Thank you, Judge.
Thank you very much. All right, what else do you have? You have, come on up here, ma'am. Alexis, Rachel, Leanne, Syler, 26W840618 A and B. Ma'am, your name?
Alexis, Rachel, and Tyler.
All right, so I have an operating with the presence of drugs and a resist and obstruct. I'm entering not guilty pleas indicating defendant stands mute. So all we're gonna do then is set this for a we're just setting this for a preacher. Just surprised they filled this out, cost of recovery. $1,000 personal bond. You cannot leave the state without the consent of the court or violate any law or ordinance. You must appear in court as directed. Did you get fingerprinted, ma'am?
Yes, sir.
$1,000 personal bond. No alcohol, no illegal drugs, no marijuana. You cannot leave the state. You cannot violate a law. You must appear in court as directed. If you want a court-appointed lawyer going forward, you're gonna have to fill out a petition for one, okay? And we'll give you a court date on this one out of Woodhaven. Heather, for when?
That'll be April 15th at 9:45.
April 15th at 9:45. Do you understand that, ma'am?
Yes, sir.
All right. Anything else?
No.
Good luck to you, ma'am. Again, if you want a petition for a court-appointed lawyer, you're gonna have to fill one out, okay? Thank you.
That's for there's a discovery order from the prosecutor.
That's for the lawyer?
Yes.
Okay.
You don't need it, you won't. Okay, you want a lawyer. You got one more. Mr. Crawford has 2 more he's working on now.
And we also still have those 2 felony arraignments that Mr. Baldwin is still in on one and needs to speak with the other still.
Okay. So I filled out this order for discovery and the bond sheet. And so you can take those out. I'm putting them in the file A, the operating presence. All right. So you got 2 arraignments left.
Baldwin has 2, Crawford's still working on 2, Mr. Eanes has 1.
Okay. All right. Stay seated, everybody.
Your Honor, for arraignment purposes, we'll waive MU, please.
Been arraigned.
Oh, she has.
Yeah.
Well, even better. I take all that back.
Very efficient.
Your Honor, Mr. Cook and I have had some discussions. We're asking for an adjourned pretrial for Ms. Hardesty to do some things behind the scenes. So if Your Honor would give us 4 or 5 weeks to get those things done. Yes, maybe 4 weeks.
Anytime. Okay.
June 3rd.
That seems like a.
That's like 8 weeks. 6. That's like 4. That's it, right?
That's the perfect file. Yeah.
It's okay.
We thought you had a vacation. And then that wasn't likely.
Apparently, I'm taking a month off. I don't know. May 6th, 2026, 9 a.m. Continue. What was? Okay, sorry. We'll talk later. Court does call the case of the people versus Joshua Warren.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Judge Lawrence Margolis with Mr. Wara. Josh, please unmute yourself and state your name.
Joshua Warren. How you doing, Mr. Warren? Good, and you, Judge? I think I'm doing okay. All right, where are we on this case?
So this is, I think, set for a competency hearing today. He was found competent. Mr. Cook and I are in discussions for a global resolution. Josh has several cases in this county, and we're hoping to get them all resolved. We're asking for 2 to.
I don't have. Do you have me set for a comp hearing? I think it's set as a pretrial. I think the comp came in another case because I don't have a report.
Okay. We'd ask for a short adjournment. We're going to try to wrap everything up. Josh is doing well. He did 2 short hot
Will
one short.
Will April 15th work? Or you need something like in, I don't know what month she's giving me, like August? No, I'm kidding.
April 15th, I'm actually leaving town to go visit my daughter in Spain. if anything, 2 weeks after that would be wonderful, or,
May 6th. Will May 6th work? Apparently that's the day.
it will for me.
All right. May 6th, 2026, 9 a.m.
Thank you.
Make sure YouTube got a good look at the back of my head again. That just covers up the reflection going to mine, so.
Absolutely does. That's a big blur. But that's what you normally look.
I appreciate it. Yes, yes.
26 CR 116. Where's Alam Khan?
Khan.
Come on up.
Sure. All right. And so it's not that big one. No, it's not that one. Okay.
You were Alam Tajik Khan?
Alam Khan, yes. Indeed.
Alam Khan? What is your cultural background? Where you?
I was born and raised in Russia.
Ah.
And then my father is from Afghanistan. And then I moved here in 2004.
I'll be honest. Okay. Welcome to the United States.
Well, he's a citizen, Judge. So he's,
Oh, that's great. I mean, we're a melting pot.
yes, sir.
Very proud of it. That's what makes us special. All right. Unfortunately, you know what you're charged with. This is not something. Have you ever been in the criminal system before?
No.
Fix this. Don't make this kind of mistake. Fix it. And he's going to help you.
Yes,
All right. You're charged with a state jail felony solicitation, and it carries with it up to 2 years in a state jail. And it's a felony. If you get a felony conviction, that follows you. Do you know how long it follows you around when you get a felony conviction? The rest of your life. Okay. We don't want that. Fix it. What are we going to do today?
Judge, I'm just asking for some additional time on this. This is our first appearance, first evidence.
Now?
Yeah, hour. Yeah, at least maybe 6 weeks. Realistically. So
how about, can we set it for 5?
5 is fine.
Oh, get a reset.
Sure. She's going to do a sign and us. Yeah, this and then
Tammy.
Okay, yeah.
LeBlanc. Tammy LeBlanc, please. 25 CR 657. Is that the one? Ernest LeBlanc? Is that her? She's coming up?
Yesterday. Miss LeBlanc's case, I expected to have a dismissal for you this morning from Miss Porter. She's paid restitution in exchange for a dismissal. That takes care of. I just think we're waiting on the motion to dismiss.
How much was it that you paid back now?
Exact amount that I paid for restitution to both parties.
Okay. Oh, I'm looking, I highlighted this, $2,746.45.
Yes.
Yes, Judge.
Okay. Bunch of different numbers there.
Yes, Judge.
That's been done.
It's been paid as of Thursday of last week.
Okay,
And I
is there
know
anything else?
we paid it, so we're just waiting for the motion to
Okay.
dismiss.
Well, I'm sure that will be done. It may not be done today, but it will be done. And I don't see any reason for anybody to come back unless there's a problem. Y'all alert me, but
I'll take care of it.
state takes care of their business. Hasta luego.
Thank you.
So she said.
Samantha Scoggins.
Just this.
2671. You're Miss Scoggins? Hello? Is that right?
It's
It's
Oh, and let me look at this.
morning. How are you? Pretty good.
Whenever we see that in space, they can work working up or we should have to do.
Punishment range, this punishment range is different from a regular first degree felonies, I would.
Yes, Judge.
All right, you are Samantha Scoggins? Yes.
Yes.
All right, she has to hear. You're here with Mr. Gertz, your attorney and the state's attorney. You know what you're charged with in 26 CR 71, the first degree felony of sexual abuse of a child, continuous sexual abuse of a child. This is a most serious felony according to the legislature. They enacted it, and very few criminal laws are this severe. But if convicted, you are looking at a minimum of 25 years in prison, minimum, up to life imprisonment. Plus, I believe there's no parole.
That's correct, Judge. And we've discussed it.
Okay, it's a very serious matter. Most serious. So it's going to take responsible decision making here. All right. It's an announcement.
I'm asking for an additional announcement setting, Judge. 6 weeks.
All right. Anything from the state? It was indicted in January, so.
Nothing from the state judge.
6
months.
Got it.
Thank you. So,
Kevin.
Judge, we'll work out a deal on that. We just need to pay. Walker.
Is Langston?
I'm here.
Here?
Here.
Hakeem?
He's here. Oh.
You're always in the front row. That's why I'm always looking over in the back. You're always on the front row. Oh. Keisha, did Keisha show up to work today? More?
Anisha's here.
Hey.
She's here.
Okay.
Can I leave? Should I be home?
It's hard to get up and soar with the Eagles when you're spending all night hooting with the Owls. A lot of owl hooting going on last night.
Uh-oh. Yeah, I almost close that well.
Oh, it's a secret. You had to be there.
Hey, I missed that one.
Okay. You're Hakeem Richard.
Yes, sir.
And you're here with Mr. Adams, your attorney. Charged with a state jail felony of evading arrest or detention. And that would, if it were only that, you would be looking at up to 2 years in the state jail. But we got.
Well, it's a misdemeanor enhanced, isn't it?
Yes, but he's got.
Yes, misdemeanor enhanced.
It doesn't have to state jail.
But you've got paragraphs 3 and 4, prior felony, prior state jail convictions in sequence. So what does that do? Is it still, makes it a third, doesn't it? So it's a state jail felony, though punished as though it were a third degree felony. So you're looking at up to 10 years in prison. The problem you have is these prior convictions are never in the past. They're always there to be resurrected when you commit a new felony offense. It'll come back and it adds to the problem. That's why you got to put that in the past and move on and don't revisit criminal behavior, because what's in the past is never really in the past when it comes to criminal law. It comes back and it adds to the punishment. And that's what's happened in this case. So it's just not 2 years. It's every time you commit evading arrest, You run from the police, you're looking at a third-degree felon. You're looking at 10 years. So my advice is don't do that. Okay, it's an announcement. What are we doing, Blackstone? Hello,
Well,
it's an announcement. Let's go.
So, well, let's do this. Just, can I have one more announcement on this case? Because I think the issue, I understand it's a misdemeanor that's enhanced to state jail, but punishable as a third degree. But
it's the way it is.
Well, no, I'm not arguing this. It's his current situation when he's working, he got a job, he's, for the most part.
You're gonna lose your job if you can do 10 years in prison. Yeah, probably. That's why you gotta figure something else that you can work around. But most importantly, don't do this. Shouldn't even be in here. You've been in this in the past, you know, mistakes have circumstances and consequences. Don't do this.
Well, the thing, Judge, is the current office of 2 years in the pen. The reason I'm asking you for one final announcement is that what we might end up deciding to do is to go unagreed if the state is going to.
I'm gonna give you 2 weeks to
That's
think
fine.
about it.
And then I can talk with him about the option of going unagreed to the court.
Okay. All right. Jansen Bailey, where's Jansen?
If you wanna go on. No, I have to think about what I'm used to cap, but I'm not.
Reagan Manaldi?
The situations, but.
I was just calling your name. I didn't call your name. I stayed on it. No, we have Nehemiah Olmsted. That you? 25 CRs, 389 is called. Nehemiah Edwards Armstrong, you're charged with a second-degree felony and burglary of a habitation, which is not a good thing. It carries with it up to 20 years in prison. Nobody wants that. It's a minimum of 2 years. So serious. And Ms. Manali is here helping you as an announcer. What are we doing about it?
Judge, he just brought up some records that I'm gonna use in negotiations to my office yesterday. I have not had a chance to review them or provide them to the prosecutor.
That'd be nice, but it's been a year old. You need to bring records quicker to her if it's going to be something important. This case is now a year old from indictment already. So when it gets that old, the time period for making a fish or cut bait decision gets thinner. How much time do you want?
3 weeks.
You got it.
Thank you.
Don't wait till the last minute to give her information if it's important. Is it Dalian or Dalen? Douglas?
Yeah.
That's you, Dalen Douglas? This is about evading arrest. Here's this television, movies that causes this. Everybody wants to run from the police. Get in an accident when you're running for the police and you hurt or kill somebody.
What's the action?
It's murder. So. Well, this is a foolish thing to do. But this is on the same day. It was a stolen car. Unauthorized use of a motor vehicle, it says on the same date, and then evading arrest. Is that what happened?
Yes, Judge.
Stole a vehicle and then ran from the police when they were chasing him or something? Okay, it's a third-degree felony for evading arrest or detention with a motor vehicle. Say that right. And that's carries with it up to 10 years in prison, and then unauthorized use of a motor vehicle, which is serious. A vehicle is the second most expensive thing somebody owns. So it's like stealing a home, almost, only not, I guess, quite as bad, but stealing a vehicle is $20,000 to $40,000 generally. And so it's expensive. This is a state jail felony. So that carries with it up to 2 years in prison, one up to 10 years, one up to 2. So you're looking at 12 years in prison on this. Do you find that important? I would. What are we doing today?
Judge, I just got an offer on the 2 cases this morning. We were waiting to see if there were any other issues that were coming through. We have confirmed that they're not, so I have 4 weeks to go over that offer and information with the client. Thank you, Judge.
Brianna Hope,
Can we hold on her, Alex, to Mike about?
hold on that. She's needs some more time. Caleb Ledger or Leger? Caleb Ledger, Leger? Two cases. 25 CR 1410 and 1411. Caleb Deshane Leger or Ledger. No answer in the courtroom. I asked the bailiff to call into the hall for Caleb Ledger or Leger. Charged with 2nd-degree felonies of aggravated assault. What are his,
She went too fast, too far.
no response to the bailiff call into the hallway. No response to that name being called here in the courtroom. Defendant has failed to appear.
Then bonds of 25,000 in each case.
His bonds are revoked. Warrants are issued for his arrest. There.
Oh, Judge, I believe that's him walking in right now.
Who is Caleb Leger? Where you been? It's, sir, you were what?
I don't think I'm in the car, I think it's a change, so I'm moving a little bit slower.
This morning?
No, today, so. And we got car state traffic, went to a fire.
Yeah, it's important. You gotta be here on time. Come on up. When your name is being called right now, we almost revoked your bonds and doubled them and sent warrants out for you, which is what happens. Everybody else is here on time. You gotta be here on time. It's important. Okay. That's you, Caleb. Is it Ledger or Leger?
Leger.
You're charged in these 2 cases, 2nd-degree felonies, aggravated assault with a deadly weapon. These carry with it up to 20 years in prison on each case. 40 years in prison, 40. Serious, deal with it seriously. Ms. Minaldi here is your attorney?
Yes, sir.
Isn't it?
I need to talk to him about everything. I need 3 weeks on it, please.
It's a half a year old already.
I understand, Judge. I'm working on it.
How much time?
3 weeks.
You gotta work with her. On this, y'all gotta work together.
Yeah.
Or you having trouble at all getting in touch with him?
No,
No.
we have subpoenas out for certain things and things that we're looking at, so I just need some more time for that.
Okay. Great. You have a reset?
Thank you. Sorry. Just sign
Brianna.
We're holding on to her, Judge.
We're holding on to Brianna. Caleb Leger. Huh?
We just need to.
Yeah. Monique, this is a new one. Dominic Rubin.
Thank you.
25 CR 977 is called. Are you Dominic Rubin? That was a question. Are you Dominic Rubin?
Rubin, yeah.
Yeah. You are here in 25 CR 977. You're charged with the state jail felony of theft because you have 1, 2, 3, 4, at least 5 convictions of thefts. If you steal a pack of gum, it's a felony offense for the rest of your life. Okay, you know that, but here you are. All right. It's what are we doing?
So she's requesting to set her case for trial. So.
Okay. I'm a little fuzzy on this, on the second line, second paragraph, the punishment range, does it, is there any?
It's just a
Because
state
of the
jail.
priors, it doesn't matter how many county court of law priors of theft she has, it's not going to adversely affect the state jail felony.
No, Judge, it remains a state jail.
Okay.
Since they're all
Then
thefts, it's just.
That's what
state
we're
jail.
gonna do. Then we'll set this for trial as soon as possible. And that's what will happen.
Thank you, Judge. However, that's all. No, I'm.
Renuka Holiday?
Present, Judge.
That's you?
Yes, yeah.
All right, in 25 CR 846, you're charged with the 3rd-degree felony of injury to a child. This is a 3rd-degree felony, which carries with it up to 10 years in prison. I'm looking at a paragraph 2, which states you have a prior conviction of felony offense in 95. So I guess this gets bumped up if all of this is found true to 2nd-degree felony punishment. You're looking at up to 20 years in prison in this. Do you understand?
Yes.
Serious. It's an announcement today. What are we doing today?
We're asking that this be placed on the trial.
All right. Everybody wants trials. But that's okay. That's what the Constitution is all about. This. That's the way it is. Get it reset. And that's what we're gonna do. Try case.
Highlighted that.
You understand, ma'am, in trial, if you're convicted of this trial, you're not eligible for probation.
Yes.
Bruce on Cordarius Williams.
Yeah, you got these first. That we had reached an agreement that's going to except that he is finishing up his the Jasper school district. He's finishing up 2 buildings over there. And he just needs 3 weeks to be able to complete that. And when we come back, because he is going to go into state jail, our agreement is
3 weeks, is that what you're asking for?
15 months state jail.
3 weeks. Stay. We're gonna postpone this 3 weeks. So
3 weeks.
you're gonna be coming back to enter a plea.
4 weeks. Yeah, he's going to finish.
What's your final answer on this?
4 weeks.
Gloria, okay.
It needs to be walked the court.
No.
We're not available, so we'll have.
4 weeks, good. Thank you. Get a resetting for disposition. Thank you. Javante Bailey. Brent. Javante Bailey.
I think we have something worked out, Judge, if we can pass on that one and come back to it.
I got somebody else's, is it Brian's working on a?
Yes, sir.
David Graham. Is the other one, is next. David Graham.
Mr. Graham.
Okay, 25 CR 1177 is called State of Texas versus David Graham. That's you? It's a state jail felony of theft that you're charged with, carried with it up to 2 years in the state jail.
Can I get a few minutes to talk to Mr. Graham, Mr. Toilet, for a few more minutes, Joe? To watch him in this case.
Okay. It's a happy year old.
Yes, I'll visit with him.
Okay. Put a little after.
Yes, sir. We'll come back and I'll tell you when we're there.
Okay. Alberto Toledo. Is it Toledo or Toledo? I don't know.
Need to visit with him this week. I didn't respond when I called him in the earnings this morning. So, I'll visit with him for a few minutes and then we'll come back.
That's you, Albert. How do you pronounce your last name?
Toledo.
Toledo, the third.
Yeah.
See, all right. You were charged with a third-degree felony of obstruction or retaliation in cause number 25 CR 1803, which means if convicted, you face up to 10 years in prison. Very serious. Mr. Turk here is representing you. He's going to be talking to you here in a little bit. Make sure you tell him everything you know, so that he can help you in this case. You understand? Okay. Sean Washington, please.
Mr. Washington, I'm going to try.
She was saying that.
Everybody wants to pass.
Well, the state's still kind of confirmed some stuff.
Every trial here is a world record.
So,
as you know,
they're still working on their end of it. They just haven't gotten back to me on some things. Not you.
Whatever.
So, in the meantime.
Hold on. We're looking at. What is this? A digital trial? Yeah. I believe so. Lost possession of a firearm by a felon in 25 CR 1839. Let's see. Well.
No, that's the one. It's repeat.
I just have one, Judge.
So you have a charge.
I jumped off.
And then.
Grab somebody else's top. Yeah.
If you say it. Goes from the third to second.
I looked at the next, there are some, the next one's got some issues there.
It's just the one enhancement. Take it to a second since it's good for me.
Okay, on Sean, he's, yeah. He's got this is a third degree felony for the offense of theft, which carries with it up to 10 years in prison, but you have that prior 2013 conviction out of Travis County, which then bumps this up if convicted to a second degree felony punishment. So then you're looking at up to 20 years in prison.
Yes, sir. We're working with Ms. Porter on this one because apparently she's trying to check with Enterprise, who's the complaining witness on this, to clarify what's going on with her on their side. We just haven't heard back from her yet.
I show the vehicle was recovered, Judge. That the restitution is $574.96.
We have some, we're trying to take and see if the restitution's been paid because what Mr. Washington is giving me is showing a clean bill of health with Enterprise. So the state's trying to verify this. That's what I spoke for.
We got another problem. This thing is over 2 years old. No. How long? I'm gonna give you minutes, not hours. Come on. I mean, it's 2 years old. It's over 2 years old. 2 years and a month. I mean, this thing's stale. We can't we can't conduct business this old. I mean, this
I mean,
is 25 months old and nothing. I know you have some stuff here, but y'all gotta make a decision one way or the other.
Well, Judge, I think the ball's in my court, so I'll call Enterprise real quick and see what everybody else hasn't found out, see if I can find out something. Just give me a minute.
Wait, stand by. Yeah, I mean, 2 years is old.
Yes, sir.
Things that need to be, you know, something like that. It's like a phone call. That should have been known. Truly.
We'll see.
Vernon Williams.
That's fine, Connor.
That's it.
That's what I first name on it, it's my passion.
Those priors go on and on. And on, so. That's you, Vernon Williams?
Yes.
You're charged with unlawful possession of a firearm by a felon. But all the priors, this is showing that you are an habitual felon. Which means you're looking at a minimum of 25 years in prison to life. You understand?
Yes,
Very serious.
Yeah.
I mean, it was.
Understand.
You were a habitual felon 2 convictions ago. Since 2018. So here we are. Yes. Announcement.
We can get about 4 weeks from now, so I can something straight down on this. It's not that, yeah.
It's not.
Yeah. We need more time to just help look out, get it resolved.
Yeah. Okay, I'll reset it, 4 weeks, give it resetting, have a seat right over here, please. Probation,
Not on the highlighted next one, please.
let's put him in the penalty box. Thank you. He's got drugs in this arrest. Robert Chason? Ryan, when y'all are ready, you let me know.
Yes, Judge.
Chason? It's 25 CR 1845 is called the state of Texas versus Robert E. Chason. That's you? Is that yes? Okay, she's got to take everything down. That's why you can't. But you can't figure out what that means. You're here with your attorney, Mr. West. You were charged in this indictment with the 2nd-degree felony of assault on a peace officer. And that carries with it no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you are facing here, sir?
Yes, sir.
All right. This is an announcement.
Your Honor, we've gone over this case, talked to my client.
How's that working?
Yeah, that's working fine.
Oh, good.
But my client is not does not want to take the offer, so
Trial.
there for trial.
It's set for trial, and just have a seat right over there before you leave. Get a resetting person.
You get right there.
And then, I mean, hey, hold on.
Highlighted X?
There was 2 cases.
Yes, 2 cases.
Mr. Chason, we're not through. Sorry. You had another charge here in 25 CR 1846. You're charged with harassment of a public servant, which carries with it, it's a third-degree felony, so that is no less than 2 nor more than 10 years to be found in prison, and a fine up to $10,000. What we will do is, let me see the previous file, please. Let's, since you don't. That's a player. It's the same event?
Yes, sir, part of the same incident.
I'm sorry, did you say, yes, no? Those are the words, hidden in the dictionary. What's they want to do on this? Try them both at the same time? Or?
I don't know what I want to do on that
Okay.
at this stage, Judge.
Okay.
Likely I will try the assault first.
Well, it's second degree felony. So you were looking at up to 30 years in prison for both of these. Do you understand?
Yes, sir.
Okay, you got a resetting, have a seat over there.
I don't think he's on.
Not yet. Yeah, judge called back for it.
Designing Matherson.
It's a defendant. It's not going to be available.
Does he have fires?
No.
And it's nothing listed.
No.
It's. That's you?
Yes, sir.
Designing Matherson in 25 CR 1665. You were charged with the third degree felony of stalking, which carries with it no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range applicable here?
Yes, sir.
And
You could put like number.
you're 18 now?
Sir.
You're
You're gonna place it right here on the box, don't roll it. Yeah.
Well, you're gonna be charged as an adult when you're 17, and I guess you was 17 at the time of this event.
Yes, sir.
So this is very important. Number one,
There's a comment just then.
I guess you're still in high school.
Yeah.
You just don't want to go to prison. For sure. And conviction carries with it, well, it follows you the rest of your life. So it's very important that you work with your attorney on a responsible method of disposing of this. Today,
If we get about 4 weeks, me and
You got it.
Larry have been talking about this case. We're trying to get it, we're on the verge of getting it resolved.
4 weeks. Please get it reset. Thank you. Railing Phillips.
Go into that one.
You're Mr. Phillips?
Yes, sir.
In 25 CR 1637, sir, you are charged with a third degree felony of assault on a public servant. And it says you struck a police officer in the face. No, the city of Port Arthur public servant.
Yes, sir.
That's correct. So. Well, I hope the man wasn't driving the bus when that was happening.
No, they were a big part. Stopped.
All right. That looked like that was a dangerous situation. Fighting with a bus driver while the bus is rolling along with passengers. That's serious. And it is a third degree felony here, which carries with it up to 10 years in prison. And a fine up to $10,000 can be assessed. So that's serious. What are we doing?
Your Honor, I believe we need to set this on trial docket, at least talking to the case.
It isn't as if he did not assault.
All right,
Or like that.
set for trial.
Resale.
Gary and Smith.
All the thing earlier, I did not response on.
There's an additional charge that's going on.
25 CR 1477 is called. The state of Texas versus Gary and Smith. There is no answer in the courtroom. I ask the bailiff call into the hall for Jerry and Smith, please. Thank you. No response to that name called in the courtroom. No response to the name called into the hall. Defendant has failed to appear. A warrant shall be issued for his arrest. And his bond?
$20,000.
His bond is revoked of $20,000. Is double $40,000. Plus, he must have a GPS device and home confinement. So we know where he is when he's not in court when he's supposed to be. And he is allowed to leave home only for purposes of court, meeting with his lawyer, food, medical service. And he must and work. And is he working? As far as you know, employment, and he must take the most direct route possible to and from those locations and events. Devin Thompson. That's it. Twenty-three CR 1059 is called State of Texas versus Devin Wayne Thompson. That's you.
Yes, yeah.
Here in this case with a third-degree felony of evading arrest or detention with a motor vehicle carrying with it up to 10 years in custody. Today.
Your Honor, we've just not had a chance to meet. We've been missing each other. So we need to go over discovery and review everything. So we get about 4 weeks.
What's an old case? I mean, this was indicted in August of
I haven't had
23. August of 23.
I don't know why, but
It's 2.5 years old.
this is
I'll
our
talk about it now.
Yes,
Thanks.
we can. I mean,
Let me know if there's something. This is 2.5 years old.
But I don't think it's been on the docket many times. It's my first experience on this.
It's what it is. It's 2.5 years old.
Oh,
I mean, it's. He lived in Port Arthur and now he's living in Lake Charles.
Yes,
but
no.
I don't know if that was the
But
problem.
the thing was that,
Brady and myself have past ideologies that were.
It does look like he was arrested October 31st of 2025.
and he was arrested on March 12th. So
I think he may have been released before.
he knows he was booked in. I mean, you knew there was something wrong that you're going to have to deal with. But yeah, this is stale. Tell me what you're going to do. If anything.
Yeah, I'm not sure. We'll be able to go through everything today. Or we can do short.
Who's ready?
But yeah, just
Ladies first. Don't try to pull the I'm going to wear a dress next time thing. Just to get ahead of the. Who do you have?
She is
Yeah. That's a.
Brianna Hope?
She's speaking with us. All right, here. You go stand for the judge.
That's you, ma'am?
Sure, sorry.
That's okay. Your attorney left. I don't know what that meant. That's not a good sign. Well, he's back. Now this prosecutor, he's
She told me there.
he's back.
Be good.
We now call 25 CR 1235, the state of Texas versus Brianna McKenzie Hoke. That's you?
Yes, sir.
Present with your attorney. Thing went dark and then came back with Ms. McNally, your attorney, and it's having shudders. It's shuddering.
It's adding people. See, it's adding people on.
And the state's attorney is present. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed?
Yes, Judge.
In summary, ma'am, this indictment alleges that on or about June 30th, 2025, last year, in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you were charged with?
Yes, sir.
This is third-degree felony, which carries with it a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached between you, your attorney, and the state that you would be pleading guilty, not found guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $500,000.
I think that would exceed the.
Yeah, when you put the other zeros in there. Yeah, $500. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
I'm there to hear you.
Are you pleading guilty voluntarily and because you are indeed guilty of the crime?
Yes, sir.
All right. It was April 1st. I thought you were pulling an April Fool's thing on me. If I follow this appeal again, you have no right of appeal. How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I show you it's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered in without objection, it's admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true to state, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence reports away.
Yes, Judge.
I'm going to follow this agreement. I'm going to find that you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. And there's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. So long as you follow these terms and conditions of probation, you will be placed on deferred or unadjudicated probation for a term of 6 years.
Yes, sir.
And you will be fined $500. There will be terms and conditions of probation that are normal and customary. One of the things I think we're going to do is also order you to complete a safe drivers program. And that is a two-edged sword. Number one, it's inconvenient to do it, but you need to take it. You do it. You pass it like you're supposed to, as required, your insurance will drop. Make sure you follow these terms and conditions of probation. If you fail, your probation could be revoked. You could then be found guilty and sentenced. You're looking up to 10 years in prison. Okay, so there's a premium on doing well. You're going to do well.
Yes.
Good, good for you. Okay, please see the probation officer. Thank you.
Thank you, Judge.
Excuse me. You're always excusing yourself.
I'm always blocking some of these.
On, I have some dismissals here. There's one on Tammy LeBlanc. Is that yours?
That was fine.
Okay, we are, or is it right to dismiss this right now, or is she entering a plea?
No, Judge, she was in exchange for restitution.
Okay. 25 CR 657, State of Texas versus Tammy LeBlanc. That case is hereby dismissed due to full payment of restitution as required.
Actually, I think that's fine, man. It's the moose coming off of bourbons.
I have a motion to dismiss on Kevin Walker. Is that based upon a plea he's going to make? Okay. Who's on Kevin Walker?
Mr.
Do you have something?
I'm just waiting to do.
No, you're
Mr. Lynn, is there anything you'd like to add other than what's in your petition?
I didn't even know you could have this expunged, but I was my grandson had to be foster cared. So when Child Services got involved with me, that's how I found out about this. The first meeting, you got to tell them everything that you have in your history. And then the second time when I met her, she brought me the paperwork and said, you should get this expunged. It'd be so much easier if anything else ever happens.
We had a jury trial Monday and Tuesday, and I literally had two jurors on there that had very, very old, one was a felony and one was a misdemeanor, old convictions. I said, you need to get these expunged. So when you're asked a question, you have you say no.
Right.
Anyway.
But that's the reason. So in case.
Well, I mean, that's a good reason, but you know, most people don't know. And even in the last 10 years, I'd say they have really expanded the eligible offenses that can be sealed or expunged. And again, it makes it easier, certainly with all kinds of different issues in your life. So
yeah, mine was just about family and taking care of, so they don't go into actual foster care, you know.
Sure. I mean, I get it. All right. Anything else, sir? All right.
I made a mistake, and I was going through a divorce at the time. That's no excuse, but I've not done anything else wrong. I mean, I don't know what to say.
You're fine. The court is going to make a finding that the required time period has passed since the defendant's final discharge from his criminal case. There are no criminal proceedings currently pending against him. The offense is certainly eligible to be expunged, and the applicant's interest in having the records expunged is not outweighed by any legitimate government need to maintain the record. So I'm going to grant your request. If you just give me about 2 minutes, I'm going to finish up this entry and file it electronically. It's done. Congratulations. Mr. Logs is going to hand you a copy of my order expunging it. You need to hold on to that for your records because it will be the only record. Everything else is going to be destroyed.
Okay.
All right. Thank you. Congratulations, sir.
Yeah. Thank you. You have a good day.
You too, sir.
You too, man.
Kevin Walker.
Let's do that way.
Ready, Judge, I'm already.
Yeah. Was it good? I'll print it on, maybe I'll print it on, I will see picture. Right, that's like it. Let's see, remind me.
One Kevin.
Yeah, it's
All right, which one is he going to be pleading to, and we will dismiss the other?
endangering.
0358.
And then 2054 will be dismissed. Right there. We now call 26 CR 358, the state of Texas versus Kevin Wayne Walker. Youth, with Mr. Gertz, your attorney and the state's attorney does the defendant through the formal reading of the indictment and the arraignment. In this case, can we proceed in summary?
We may, Judge.
In summary, this indictment alleges that on or about April 15th, 2023, in Jefferson County, Texas, you committed the state jail felony. Is that right? Yes, Judge. The state jail felony of abandoning or endangering a child. You understand what you're charged with here. If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement has been reached in your case where you would be pleading guilty, but you would not be found guilty so long as you follow the terms and conditions of probation. Have you ever been convicted of a crime? You don't want it. So this is the key to your success and keeping your record clean. You don't want a record. You know how long a felony criminal record lasts? The rest of your life. And it closes off all kinds of doors of opportunities and chances of bettering yourself. So you're going to be placed, you would be placed on deferred or unadjudicated probation. Deferred is postponed so long as you follow the terms and conditions of probation. You will be fined $1,000. And it looks like it run concurrently with a misdemeanor case. There's a misdemeanor case somewhere out there.
CW case.
And then it says, it's checked DWI conditions. What does that mean?
It's just an instruction for probation that it would be like he was on DWI probation.
That's
correct.
what
Judge.
everybody is, in this case, not the misdemeanor.
That's correct.
This case. All right, what do you want in the length?
Oh, I thought we put.
Just say 5, that's what you want? Okay.
Yes.
This will be for 5 years in length. You do well, though, it's shortened to 1/3, which is 1 2/3. It's I know you're thinking, nobody said there'd be math. Nobody told me there would be some math.
I'm sure it's.
If I follow this agreement, you have no right of appeal of your case. Do you understand? So how do you plead to this? Guilty or not guilty?
Roll out.
Well, she has to take it down.
Oh.
Yeah. Once again,
Guilty.
are you pleading guilty, both of you?
Both of us.
Pleading guilty voluntarily and because you are guilty?
Right.
Okay. I'm not making this stuff up. This is just happening. All right, I'm going to show you what's marked as State's Exhibit 1. Did you sign that document? Understand it, discuss it with your attorney, and did you voluntarily sign this? State's Exhibit 1 tendered into evidence.
We have no objection.
Without objection, it's admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer? All of this is true. It states so, help you God.
Yes.
States Exhibit 1, part of the record for all purposes. Pre-sentence reports waived here.
Yes, please, Judge.
I am going to follow this agreement if nothing further. And I am finding that you are mentally competent to enter this guilty plea as freely and voluntarily made. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted you to find you guilty beyond a reasonable doubt. But I'm going to instead defer or postpone any finding of guilt so long as you follow the terms and conditions of probation that the probation officer is going to go over with you that I am about to sign. Must pay a fine of $1,000. There will be terms and conditions, which are normal and customary for this. Also, a DWI education course must be successfully completed. And I told you there's a win-win. Number one, it satisfies the requirement of this probation condition. Plus, you're going to get financially a discount on your insurance, automobile insurance, which you have to drive. And let's see. This will be for a term of 5 years.
Yes, Judge.
All right. Mr. Walker, have you understood what's happened today, sir? Good luck. Please see the probation officer. Thank you. Okay. Here's, I'm missing a page. Finish. Can you get this to the probation officer? Yes. Thank you. Here, thank you. Both of you. You failed. Vernon, come on out. You tested positive for marijuana. Yeah, they all did, but it's in your system. And it's the way it is. Shouldn't even be around it.
Did you have TC?
Mr. Williams. All right. Okay. I'm learning. You've tested positive for tetrahydrocannabinol marijuana. That is, it's a crime to imbibe and possess marijuana. It's in your system. It's going to affect your bond. You have a $50,000 bond and a GPS device right now. Is that right?
Yes.
Is that what I just?
Yes.
All right. Yeah, he's got a GPS device, right?
Right, yeah.
And, all right. Well, you've tested positive. It's a $50,000 bond. It is revoked. You are now $100,000. Plus, you must have a drug patch at all times as a condition of your bond.
So, Your Honor, I know he says not THC. He says he hasn't used any products, but he does have a medical marijuana card. And he hasn't used any, but he has a card that allows him to do that medically. I mean, I know the court has a different feeling on that.
I do.
I understand that, but I'm just saying that this is something that there's a medical.
I'm sorry. Your bonds are revoked, period. It's the way it is. Drugs on my watch and not allowed.
I haven't smoked in marijuana.
I don't care. They all say that. It's in your system, sir. Everybody says that. And wouldn't you don't you think if somebody would just say, it's, I've never done this, can I go home now? It would be pretty simple, but that's not the way it works. We test, if it's in your system, shame on you. And I didn't grant it. I don't allow it. And that's the way it is. Y'all got to figure that out. His bond is revoked. And is it set? We said this for trial, right?
No, not yet, Your Honor.
Figure out what we're going to do.
We had a reset for 4 weeks for announcement, Judge.
Okay.
You're greater than that.
You're taken into custody. Period. That's the way it is. Robert Chason, come on out.
Excuse me, John. Can I retest?
I'm sorry. That's, sir, everybody says that, but the tests are scientific and I rely on the scientific tests.
Yes, sir. I have a marijuana club. I still haven't smoked.
Sir, you tested positive for marijuana. I'm going to rely on the science. I'm going to rely on science. Sorry. But your lawyer's going to talk to you. There's some things we might be able to do.
Yeah.
But right now, follow them. And Mr. Chason, you are positive for marijuana as well.
Yes, sir. I just recently quit 2 weeks ago. I should be
I do.
Your bond is $20,000 on each case, 2 cases. They're doubled to $40,000 on each case. The bond to revoke, they're doubled. Plus, you must have a drug patch at all times. And next time, if you can post this, it'll double after that when I test for you. But you don't come to court on drugs, period, in the ballgame. I'll give you, you get a copy of this.
Yeah, I think on the top.
What are we doing on him next?
We originally set it for trial docket.
Oh, it's set for trial, and he can sit out and dry in jail waiting. That's the goal.
Or I'm Steinberger, your building work, I want to fire you. We'll see you.
Okay, who's in the queue? Kevin Walker?
We've already.
I have a dismissal on Sean Washington. Can I sign there?
I called Enterprise. They told me to do another person.
24 CR 545. Motion to dismiss. Signed. Huh?
Mr. Washington free to go now?
I just signed a dismissal.
Okay, just making sure.
Hey, I don't have anything until 1:30.
Well, we had 9 o'clock, Judge. Mr.
No,
Bob's here.
is it a Pops?
Yeah.
Yeah, it's the first one at 1:30.
We had
Judge,
What's that?
we got some new information in on this file. I'm gonna have to file another amended because I got a video in of him being out outside of the club fighting and also some other scram device violations that we need to deal with.
Is it a issue that I need to address for bond?
Not until I file the motion. I'm getting everything gathered up so I can file it.
He's here.
Well, I know, but I mean, is it like
No.
any issues that are bond issues that I need to address?
There weren't any charges filed yet, so I have to. And I don't know about the scram device because I haven't seen what they were bringing those over this afternoon to show you. So once you look at them and order me to file a motion, then we can deal with the bond.
Yeah, it is.
Because he's had some positives for alcohol before, and then you put a scram device on him and he's got alcohol in his system again, so.
Is he on bond or probation? Or
he's on probation.
Okay, probation, let the probation officer.
They're bringing over some stuff this afternoon and they sent me a copy of a video.
Give it to them first and I'll go through them.
Yes, sir.
Okay.
Yeah.
Thanks.
Well, I need to come back and then. Or can we get it? Can we reset it
I don't want
and
to-
get the information?
I have to call probation if I need to.
Let's just go through the channels and then we can file. He hasn't. looking at what was happening on the fight that was out there, so.
Mr. Fobbs?
Mr. Bob.
Come on.
I won't say what I said, just.
We're going to go for his mouth.
Yeah. You're the center of attention now. Okay, you got. Well, this was a hearing that was going to be held. What was the hearing on?
On
It says here.
some
Restitution.
some restitution, there was a new theft case that had been filed, but there's a,
What's
some alcohol test positive for alcohol, but like I say, he has the scram device on now. We've got a couple more violations on that, and then we've got this new one.
Well, we need a hearing on that.
Yes, sir, but we haven't had it, hadn't come through. They're bringing it over probably today, and then we'll file the motion as quickly as possible.
Would have
We'll do
to
it.
ask for recess. Okay.
I just don't have enough where I can argue a bond violation or a probation violation where we need to issue a warrant for him until I get that and file the motion. Yeah, because they're bringing over the Fourth Amendment. Yeah, they're going to bring over today. Well, she said she's bringing my one over. We'll deal with all that. But when I say my phrase, I'll be able to. I'll just. Yeah.
I heard the door close.
Yeah.
She couldn't have gotten lost between the door and here. Thank you very much. Oh, boy. Thank you. 2/12/26, a third amended motion to revoke probation in each case comes forward.
Yes, sir. We're about to have
No kidding. We never get fourth, third, we never had a fourth. But we got a third.
He's arguing, just learn, because
Yes, so we produced what we produced. And it was oversight on us when they mentioned the MRIs that we should have done it and said, hey, where are these MRIs? Why haven't you produced them? Oh, the imaging centers that we provided reports from, obviously, they must be custodians for those records, those bills. I don't know why we didn't receive them. We received the reports.
However, Your Honor, the report shows that he reviewed MRIs, and that is a description. MRIs could be interpreted as films and reports. So I believe.
so how does that help you?
Because he was on notice, and
He was on notice, like, if he was on notice, ma'am, you had to produce the film.
And they did,
It doesn't, it's a discovery issue. It's crossing your T's and dotting your I's. You can't just say, well, the provider didn't give it to me. So, well, if your provider didn't give it to you and you can't give it to him, then you can't testify about that. He can't sit on the stand and testify about things that he reviewed that he doesn't have notice that he reviewed, that he doesn't have an opportunity to look at and say, well, let me cross-examine you on that. Or that he doesn't have an opportunity to give his expert to say, well, you review it. Do you have a different opinion about this film that the doctor said he reviewed?
So
he has the films.
Yes,
He said he has the.
Not because y'all provided it to him.
But that cures the prejudice effect.
No, it doesn't. It doesn't cure your error in not providing and complying with the rules, which require you to produce any document that's being reviewed by a testifying expert pursuant to 195.
Your Honor, in light.
You know, you should know this.
Yes.
You should know this. You've been on this case a year or so before you showed up today. when y'all went to docket call 20 days ago, 3 weeks ago, and I even said it now. So I moved it back so I could give people more time to prepare for trial because people were showing up unprepared for trial. So you have 3 weeks between the docket call when you say, I'm ready to go, and the day of trial. And yet in 3 weeks, because you could have figured this out, supposedly last year when we continued the case, you were going to figure this out. Remember, it was a mess last year. And I read my comments on the record where I said, I do not want to present a mess to the jury. Get it corrected. And in a year, you were supposed to get it corrected. This is not getting it corrected.
Your Honor, I move to strike this witness based on their admission that he reviewed and relied upon documents that were not produced. This is not a death penalty sanction. They've got 3 other experts who are going to come in and testify. But the fact that this doctor just disclosed he has reviewed films that were never produced is a serious discovery violation, and I'm moving to strike this witness in its entirety.
Your Honor, may I speak?
Yes.
Your Honor, I anticipate that he will testify that there is no discrepancy between the MRI report and what he observed on the films.
Yeah, that's not the problem. The problem is they abuse the discovery process. They don't produce documents that we request. They don't produce documents their own experts rely upon. And then they want to show up at trial and for the first time say, oh, by the way, I did review these and I never told anybody and didn't produce them. That is the definition of surprise and trial by ambush. And I'm objecting to this witness testifying. I'm requesting that he be struck and that his testimony be stricken from the record, along with an instruction to the jury to disregard all of his testimony.
And so opposing counsel is conflating 194.
Well, one, he's a treating physician, so he can testify about his treatment, so he can't be struck entirely, so that's denied.
Okay, but let me modify that request. He can testify as the treatment he provided, but he should not be allowed to testify as an expert because his opinions are based on documents that were, or materials.
Go ahead.
Yeah, that were never produced. They've admitted we requested them, they never produced them. They've offered no explanation as to why this wasn't done other than, oh, I'm on this case for only 2 weeks now, which is the same excuse they used over a year ago when you already declared a mistrial because of the impropriety that the plaintiffs had done with the alteration of the documents. Well, here we are again, a year later, in the exact same boat. I'm not requesting a mistrial. I'm just requesting that this witness be excluded from testifying as an expert and offering any expert opinions in this case.
Yeah, no, I take great issue with what counsel is saying. Every time that he's talking about this case, he brings the impropriety of the records. He had presented no evidence that our firm did something wrong with those records and altered those records. And I take great concern with his allegations.
So I'm gonna jump in. I think you're beating a dead horse because I get that. But at the same time, you weren't here a year ago. And you weren't here when I continued the trial, and you weren't here when the court had concerns about the presentation of the exhibits in the case.
But this is
so his frustration and allegation that there were concerns about the documents presented by the plaintiffs is warranted. It warranted a continuance for a year now, right? So I get you're just here, as you said 2 weeks ago, but you weren't here a year ago when the court was presented with the documents with what it was presented with. Now there has been an explanation. I get that. And the court has taken actions to make sure that that's remedied. But, and to that extent, you're beating a dead horse. Because we're not there anymore. It's not a year ago. We're gone and we've moved past it.
I understand.
So
it's just the same.
at least I have moved past it. And you can let the appellate court, whatever the record is, take it up and they can consider it. But I'm
Understood.
pretty much done.
It's just, it's frustrating that we're here a year
Yes,
later.
and I said that. I said your frustration is warranted given where we've been to try to get this case tried into conclusion from a 2019 accident. So we're 7 years in and we're at trial and things should be a lot better.
I understand.
Okay, so
I understand that you denied my motion to strike him in his entirety. I'd like to renew my motion to strike his testimony as an expert in this case and offering any opinions based on the discovery of use in this case, Your Honor. I understand the court's ruling. He can testify as a treating physician as to what treatment he provided, but outside of that, because of the discovery of use and the issues we've had in this case, I would request that the court please grant the motion and exclude his testimony on any expert opinion he might offer.
So he's asking you to issue death penalty sanction as to Adelardo's testimony for films that he has possession of, he's reviewed, he entertained an expert, Dr. Katzman, to review them, same films that this individual says that he reviewed.
Your Honor, I'm not asking for death penalty sanctions because they have 3 other experts. It's not death penalty sanctions. I'm excluding one person.
do you have an expert who's gonna testify as to what he's gonna testify about?
No, Your Honor, because what he's talking about, he's going to get into his surgical recommendation.
Okay,
And that has nothing to do with the thoracic spine, just so you know.
so wait, did he have surgery? Did who, whatever?
The plaintiff, no, she was.
Not yet.
So he recommended surgery,
Correct.
but she has not had it. Okay.
He recommended surgery on
And
October.
so are you trying to prohibit him from testifying about his recommendation for surgery?
I'm trying to prohibit him from testifying about any expert testimony based on the discovery of use.
Would that be his recommendation for surgery?
Technically, yes, but if that's all they want to use him for, Your Honor, I'll split the baby. I'll try and compromise.
What else would y'all use him?
We want to talk about causation with him.
Yeah, they want to talk about causation, but
You don't have someone else to talk about causation?
they do. The slide even said Dr. Singleton.
No, it said Adelardo. No, we want to talk to him about causation because we've got surgery. And then your limited opinion as to causation, I went back and I have removed all my questions regarding causation as to Reed Singleton because I could not find where he states it in his record. So I'm not going to even go there with
But this doctor does.
This doctor does.
Okay.
Your Honor, I believe that the discovery of use needs to stop. A message needs to be sent that you can't show up to trial unprepared time and time again, say, oops, my bad. I've only been on it for 2 weeks. Please don't do anything to harm our case. That's not what the rules are for. The
Well,
rules-
it's, I'm gonna think about the appropriate remedy in this case.
All right, thank you, Your Honor.
So,
Are we on break?
Go to lunch, yeah.
What time?
What time?
I was gonna come back to 45, but y'all, I'm gonna give y'all
30 minutes, Your Honor?
I can scarf down a salad in 5
I
minutes.
don't need one, so I'm fine.
I just want to eat a sandwich.
takes you 30 minutes, 20 minutes.
20 minutes, okay.
Because the jury has already been waiting, so,
12:43, can we just say 1 o'clock? Is that okay?
yeah, let's say 1 o'clock.
Thank you, Your Honor.
Thank you.
Oh, you need,
No, that's fine.
okay. No, that's okay.
No, that's fine, I'm fine.
Okay.
It's pretty good for me.
Oh, okay. Okay.
And he relied on the French form of the